I'd like to mention, my lord, item number 2, short of the list. I filed an additional evidence.
Please call it. Call it. Call it.
Acting claim by IOC informs other side.
You give the letter.
Active claim I'll be taken to this. Because in the meantime, we required to bring, I have to pass to the matter. Already informed by the other side. Much of it.
Item number 2, 2 p.m.
May it please, Your Lordship. Your Lordship, I'd like to mention item number 50 of supplementary list. Your Lordship may not pick up this matter.
I had already said,
Yes.
but again it is listed.
Yes.
It is registry to put up the list this matter before any other bench without me. Hamaरा नाम लिख दो. Maybe they have not seen the earlier orders. ऊपर लिखा दी वो है, not before me बोले. आगोट में order दिया है 50. Okay.
The concern of the other side, I beg to mention item number 46 of the daily list. Your Lordship. In this
Why?
matter, Senior Counsel Mr. Deedas appears he is out of session for a matter.
On the prayer made on behalf of Mr. D. Das, Learned Senior Counsel, appearing for the petitioners, registry to list this matter again after 2 weeks on a date to be fixed by it. 23 matter you make a mention, we'll bring it. Yes, Mr. Botago.
Lordship, may I pray for listing of a motion matter tomorrow, Your Lordship?
What is the urgency?
Urgency, Your Lordship, it relates to Your Lordship admission into polytechnic institutions. Your Lordship.
May it please, Your Lordship. And wait to mention the listing of a matter, Lordship, relating to small correction, Lordship. And another motion matter tomorrow.
Please, Your Lordship.
Yes, Mr. Bhuyan.
May I please, Your Lordship? My lord, I beg to mention for 2 motion matters tomorrow.
What is the urgency?
Lord, urgency is 1 petition. I have been debarred from appearing in the LLB final year practical examination.
Oh.
And second one, my lord, is the, my lord, we are a group of 20 petitioners, my lord. We have been amalgamated as a graduate teacher in secondary level schools, my lord. But the department is saying that your tenure of service is required to be counted from the date of amalgamation as a 10 years. Then only you
That can wait. Okay. Both you give it.
Fine.
But the first matter subject to Mr. P.J. Fukan appearing.
Lord, I will bring him this.
Please, Your Lordship. I'd like to mention item number 5. My senior's father was died, so he could not appear before.
Oh, what happened?
Yes, Lordship.
Why the adjournment?
My senior's father was expired.
Okay, Mr. Das.
UPDS.
On a prayer made on behalf of Mr. UK Das, who is stated to be in bereavement, registry to list this matter when? After 2 weeks? After 2 weeks on a date to be fixed by it. Okay.
May please.
I forgot that.
I beg to mention for listing.
What is the urgency? Before vacation?
May it please, Your Lordship. Lordship, back to mention for listing a writ petition, Lordship. Next week, Lordship. Obligement.
Yeah, please, Your Lordship. Lord, I beg to mention item number 8 and 9 of today's daily list.
Wait.
Because, my lord, in this case, the party, my lord, took back the brief from us, my lord.
When you appear, you make that mention. We are not adjourning item number, this
Because,
items.
my lord, we are not having the brief and they are.
No, you don't appear.
Yeah.
You don't appear. I'll dismiss it for default. Nothing is there otherwise.
Obligation.
May please.
Hmm.
But I beg to mention item number 37, my lord, with the consent of the petitioner. So we are filing a review, my lord, on this.
Review is already filed, disposed of.
These are review filed in the earlier.
Earlier litigation.
My lord, direction was issued to give provincialization.
You have objection?
No, no, my lord.
No, then okay, fine. On Mr. B. Kaushik, Learned Counsel, appearing for the respond number 3, prays that he be granted 2 weeks' time.
4 weeks. My lord.
4 weeks' time for taking steps with regard to the orders passed by this court, violation of which is alleged in the present proceeding.
Maybe small accommodation. Mr. Endeka is on legs, maybe taken after some time. He's for IOC.
After some time, Mr. See, when a senior counsel is appearing, You must inform him. He is here from the morning.
I was just informing you. I'm extremely sorry, man.
Mr. Kokotagi, you can leave. Whenever they are ready, they will call you.
Fine.
You can have a cup of tea and come back.
Fine.
2 to give. 2 to 3.
Look, I can see.
Yes.
Lordship,
Mr. Talda, what is there?
so
Admittedly, he had,
exactly, Lordship, isn't it?
and the allegations are there now that things that he is trying to develop. Loss of confidence has already occasioned.
Lordship.
And there is no allegation that he was denied any opportunity.
Exactly, Lordship, opportunity was given.
Everything was given. And he admits indirectly that he made those debits from the accounts of the...
Yes, Lordship.
What happened to that criminal case?
That criminal case, I don't have any objection, Lordship, so far that matter is concerned. Even if that is the.
That is different thing. That will not have any influence here.
Yes, Lordship.
And he is claiming that he was not given the video CCTV footage. And I was trying to find out whether he had made anything with regard to that deductions made in the account of your customers.
Own ID number was.
Everything was used.
Lordship,
Yes, Mr. Bodhagut.
I'm sorry, Your Lordship.
No, it's okay.
Adjournment.
What is here?
Lordship,
Mr. Talda, you have your seat.
so far as I am concerned, Your Lordship, I am agreed by the proceeding, Your Lordship.
Come to the charge sheet.
I'm,
You are a bank employee?
Lordship,
No doubt on that.
I am basically agreed by the further inquiry, Your Lordship.
It is not a further inquiry, Mr.
It, in the form of further inquiry.
It was a, what you call a course correction, basically.
Lordship, that has not been reflected from their order.
Okay, let's go to the root of the matter.
Lordship,
Let's go to the
Your
charge sheet
Lordship
is
will
at,
firstly come to page 22, Your Lordship.
I'm there, 13/1/2012. Okay,
Lordship,
there are broadly 4
Lordship.
allegations.
4, Your Lordship, and 5th is very vague, Your Lordship. These
Now
are-
you come to that on 16/10/2009.
Lordship. Thereafter, my reply, Your Lordship.
You
for a
made
moment.
unauthorized debits of rupees 6 lakhs
Lordship.
by way of 12 entries
Lordship.
using your ID.
Lordship.
Now, what is your stand on
My
this?
stand, Your Lordship, will get it at page 23 onwards, Your Lordship.
Hmm.
First of all, Your Lordship, I have denied that, Your Lordship. And in fact, my stand was this, Your Lordship. Your Lordship may kindly come to page 25.
Hmm. Hmm.
First part is, Your Lordship, factual and evidentiary explanation that I explain or declare for the purpose of explanation that the said debits were made for illegal over a conspiracy by some vested person using my ID, taking the exclusive opportunity that they were also employees of staff of SBI Dumduma branch, that there is strong suspicion that the above said illegal act of criminal intentional irregular is done by so and so with direct connivance of so and so jointly for gaining.
Now give
Now-
an explanation.
now, next come to just bear with me, Your Lordship, that
Hmm.
furthermore, last paragraph.
Furthermore,
For the purpose of explanation, I specially that the CCTV footage on the day must be taken into consideration as a best evidence for the purpose of clarity in support of my submission, and the CCTV footage should be kept secured without tampering until further inquiry, until final inquiry to be held in the decision, Your Lordship. And then in para 20, page 26, Your Lordship, I have also, Your Lordship, stated that VVR, Your Lordship, voucher verification report of those days should be looked into, Your Lordship, to identify who has done it, Your Lordship. Now, Your Lordship, after this reply, Your Lordship will find,
18/7/2012.
Lordship. Your Lordship will kindly come to page 40, 41, Your Lord. Page 40, Your Lordship. These are the documents, Your Lordship, I sought from the authorities, Your Lordship.
Hmm.
That with more, I hereby request.
What is this VVR?
VVR, Your Lordship, the voucher verification record, Your Lordship. Case officers, these photocopies of the vouchers, so and so, case rules, etc., Your Lordship. Now, Your Lordship, these were not provided to me.
Okay.
Then, Your Lordship, we finally, Your Lordship, at page 42 is the memorandum
cost.
of charge.
Same allegation.
Same allegation, except for, Your Lordship, there is allegation 5. Your Lordship may kindly, the above 4 allegations are only illustrative and not exhaustive. By your above act of commission and the confidence trust of the people which have had with the bank has been badly second and it is responsible for so and so which bank will incur, Your Lordship. Now, Your Lordship, with this, Your Lordship, Your Lordship will kindly note, Your Lordship, in this, Your Lordship, there is no, Your Lordship, the list of witnesses and the documents, Your Lordship, which documents they will rely.
Come to the findings.
Lordship, I will come, Your Lordship. Then my reply, Your Lordship,
We have got it.
got it, Your Lordship. Now, Your Lordship will kindly come to page, Your Lordship, 82, Your Lordship.
Hmm.
Your Lordship, this is the how, Your Lordship, the proceedings started, Your Lordship. Your Lordship may kindly come to page 83. Dear to IA, sir, I need following documents in connection with the inquiry. They are, then Your Lordship, these are the documents, Your Lordship. Dear to IA, whether the inquiry is conducted based on so-called notice so and so. I inquiry authority to dear, yes. Dear to PO, referring to the first line of allegation number 5, please produce documents to substantiate the allegation. PO, Mr. Das, you are advised to present the above mentioned documents as requested by defense representative so and so. Please allow me at least 2 weeks time to present all the documents. The branch manager has requested CDC to provide few documents which are not available on the branch. To obtain the documents, it may take another 2 weeks time. Therefore, kindly allow me another 2 weeks time to collect all the documents for presenting the inquiry. Now, Your Lordship, pausing here for a moment, Your Lordship. Till the start of the disciplinary proceeding, Your Lordship, they don't even have the documents with them, Your Lordship. And they have issued the memorandum of charge, started the disciplinary proceeding, Your Lordship. Now, Your Lordship will kindly come to. Then, Your Lordship, they have again issued a memorandum of charge, Your Lordship. This is the second same memorandum of charge, Your Lordship. Since, Your Lordship, earlier they don't have the documents, Your Lordship. So this again came, Your Lordship. Then, Your Lordship may kindly come to page 87. The inquiry, Your Lordship. Your Lordship will, last line, Your Lordship. I inquiry authority to presenting officer. You may proceed with the case. The presenting officer presented 3 sets of VVRs dated 6/10/2009, 36/2009, and 24/2009. We request to replace the VVRs the same dates which are already admitted and marked as prosecution exhibit 1, exhibit 2, exhibit 3 respectively. PO request was accepted because the reason for fresh ones are the copies of the originals and evidence of having checked are observed. Accordingly, the fresh documents have been marked as exhibit number so and so, so and so, so and so respectively, and the earlier one has been replaced. A set of the documents have been handed over to DR. Then, Your Lordship, these are the statements. Then, Your Lordship may kindly come to page 89. Your Lordship will kindly see. Sir, my witness is over. IA to DR. Boisho, would you like to cross-examine PW1? Yes. When did you join the branch? So and so. Gogoi, whether VVRs are printed on the same day? No. This is one, Your Lordship. Voucher verification report is one of the most important material, Your Lordship. It was not printed on the same day. Can you identify the checker of VVR marked as P Exhibit 1? No. Checker's signature is not legible and the name is not written on the VVR. Refer to P Exhibit whether VVR was checked. It was checked on 24/2009. Whether the VVR markers are checked in the recent dates, I do not know. Kindly go through so and so and tell us whether original reports of these documents are branch records. No, Your Lordship. The originals are not with them, Your Lordship. It is admitted by them, Your Lordship. When the irregularity of whether that has been impacted branch profitability of business during the year, it affected the profitability of branch consequent upon the incident, the entire set of officials are transferred. Then, Your Lordship, whether CCTV was installed and in operation in Dumdumabars during the material time? Yes. Then, do you have any knowledge about the record of the CCTV footage? No. Here, Your Lordship, they have not taken the plea that it has been destroyed, Your Lordship. And in affidavit in opposition, there is a plea that it has been destroyed, Your Lordship. It has no more there, Your Lordship. It was in the affidavit in opposition, not in the disciplinary proceeding, Your Lordship. Then, Your Lordship, as you have said, now, Your Lordship, next question. After the irregularity is detected, how many customers lost their complaints? I do not know. This is by the presenting officer, Your Lordship.
PW1. PW, it's a
PW1.
prosecution witness.
Do you have knowledge that the bank has returned money to the customer? Yes, bank has
Okay,
returned money.
we'll come back to that, Mr.
Lordship.
Portago.
Now,
Now, show me the conclusions of the
Your Lordship will kindly come to page 92.
92.
92, Your Lordship. This is also important, Your Lordship. Last line onwards, Your Lordship.
Hmm.
DR to PO. It has been observed that you have not produced the debit instruments during the course of inquiry. Could you please tell me the reasons thereof? I could not trace out any voucher pertaining to those transactions in question, nor the branch manager could make me available of any instruments. Therefore, I believe that the transactions were made without any mandate from the depositor and without any instrument. Then, Your Lordship, it has also been observed that you have not produced customers' complaints for the alleged transaction. Please let us know the reasons. Branch could not provide me any complaint, correspondence made by the customers for those transactions. In allegation number 5, it has been alleged that total amount so and so. This is not material, Your Lordship. Then, Your Lordship, in the allegation number 5, it is mentioned that the above 4 allegations are only illustrative, not exhaustive. Is there any other allegation against CSE in addition to this mentioned in the charge sheet? I have no specific knowledge about other allegations, Your Lordship. Now, Your Lordship, after all these, Your Lordship, last line, Your Lordship, page 93. Since both the PO and the DR have expressed that they do no more business to transact in the case, hence declared the case is closed with a consent of all the parties, Your Lordship. Now that means, Your Lordship, thereafter, Your Lordship, inquiry report was submitted, Your Lordship.
That's what you have to show me.
Lordship, that has not been furnished to me,
Because
Your
that
Lordship.
is a gap. Even in your petition, you have not been able to identify or categorically state, and they have also skid over the matter.
Lordship. Now, Your Lordship will kindly see.
Because if an inquiry report is done, then it would be a further inquiry.
Lordship, then Your Lordship will have to come to the next page 95.
I'm there at 95.
They have specifically used the word further inquiry, Your Lordship.
That's an English language.
Lordship. Your Lordship will kindly see. Please refer to your letter number so and so that is served on you relating to departmental inquiry for allegation of alias against you while you were working as so and so. It has decided that further inquiry be conducted by the inquiry authority so and so to cover the some aspects.
One thing,
Your Lordship will
Mr.
kindly note that, Your Lordship. Some aspects which
This
are left.
gap is around 4 months
Yes, Your Lordship.
from the closure of the inquiry.
Lordship. That is on 6/5, Your Lordship. Inquiry is closed on, Your Lordship.
We're 29/1,
Lordship.
right?
Lordship. Now, in between, Your Lordship, Your Lordship, there will be an inquiry report. The departmental authority, Your Lordship, how could he come to a finding that there is need for going for further inquiry, Your Lordship?
Okay.
It must be there, Your
After
Lordship.
this, what happened?
And Your Lordship will kindly note one more aspect, Your Lordship. This is not specific, Your Lordship. What are the lacuna in the first?
That has not been specifically identified.
Lordship, identified, Your Lordship. That's
Okay.
it will have to do, Your Lordship.
Now come to the.
Now, Your Lordship, inquiry report is finally at page 96, Your Lordship.
Okay.
In this inquiry report, Your Lordship will find, Your Lordship, so far as 3, 4 is concerned, disciplinary authority found it not to be proved, Your Lordship.
We'll come to that. We have seen that. He has page for now 110.
Lordship.
He has agreed with regard to 1
Lordship.
and 2. Also agreed with the not proved report of the inquiry officer with regard to 3.
Lordship.
And with regard to 4,
He says that it is
it's proved.
proved.
And 5, partly proved.
Proved, Your Lord.
Okay, let's come to the inquiry.
Lordship.
The conclusions are at page 98, allegation number 1.
Lordship. 98, Your Lordship. It says, after going through the inquiry officer's remark on allegation number so and so, After going through presented during regular inquiry, further inquiry by the PO complaints to NHRM, the Dumduma and the deposition made by the complainant officer. Now, your lordship will kindly see, your lordship, here, your lordship. In the further inquiry, what they did, your lordship, they have brought in 4 more, your lordship, witnesses, which was
We'll ignore that. Just clarify.
lordship.
Now, here, the only indication to you is that your ID was used.
Lordship.
Now, tell me how your ID can be used by somebody else.
Lordship.
Because that password you only know.
Lordship, what has happened?
Where is your clarification to that?
Lordship.
You have said some vested interests have
Lordship.
worked in the matter,
Lordship.
but you have not deliberately or indeliberately or unknowingly, you have not explained
That I admit, your lordship.
because if that be so,
Lordship.
that is the end of the matter.
Lordship.
Because Mr. Right from Kakkar, if you see the judgments of the Supreme Court, the Supreme Court with regard to a normal employee and a bank employee or a financial institution,
Lordship.
the yardsticks are different.
Slight different.
Not slight, totally different.
Lordship.
It's not whether the charge has been proved. It is whether the act could have been committed by you, and the concept how it will be applied is a loss of confidence of the bank. If I can come to a conclusion that the bank had lost, there should be some material that it had lost confidence on you. That is the end of the matter. Kakkar onwards.
Lordship, that is there, your lordship. But your
So
lordship,
just show me that with regard to allegation of charge number 1,
lordship.
that your ID is ID number anybody can know. But the password, it's only, and it's a very,
Lordship,
it's a very sacrosanct
lordship.
material. No employee normally gives it to the other, cannot give it.
Cannot give it, your lordship. But normally what happens in certain situations, your lordship, this kind of, your lordship, on bona fide belief, your lordship, this was, your lordship, done. Nowadays, your lordship, things are
So
different.
if that be so, the person to whom you had given it,
Lordship.
you should have brought him as a,
Lordship, one aspect, your lordship, my case, your lordship, I admit that, your lordship, that this, he should have, your lordship, explained it, your lordship, in his, your lordship, in the departmental proceeding as well as in his
and you
reply
now
also.
rely on the debit vouchers.
Lordship.
As far as I can know
Lordship.
with regard to the transaction, if I go to a bank, I will give an instrument. It can be a check, can be a draft. It can be even that slip,
Lordship.
which debit voucher. So I sign on that. It is given to the cashier or the office. Then somebody, an intermediary officer, senior officer will verify it from the account. Now, in here, the allegation is that you had deducted this amount at a different point of time. There may not be a debit voucher. Because this allegation is that you have yourself debited that
No,
account.
that is not their case, your lordship, that these are not available. They are not saying that these are not, it is there, your lordship. But originals are
See,
not.
allegation number 1,
Lordship.
that on 16/10/2009, you, without any valid mandate of the depositor, made unauthorized debits of rupees so-and-so by way of 12 entries using so-and-so. Without any valid mandate.
Lordship.
So you will have to show that, see, these debits that were made, 1, were made to a particular customer. 2, that if that was not the thing, this was not made by me, but my ID, my password, I had given to so-and-so.
That is not there, your lordship.
Then-
That part, your lordship, I am not there. But
Because
the first part, your lordship, is concerned, your lordship, that there are 2 things, your lordship. And in the meanwhile, your lordship, there was a criminal proceeding also against me, your lordship. I was acquitted in that proceeding. your
That
lordship.
is nothing new.
That's not as such method. But only thing, your lordship, if we look at your lordship, materials relied on by the authorities, your lordship, ultimately, your lordship,
This court will go to the root of the matter.
your lordship will kindly see.
I'll not go into technicalities. If you can disprove the allegation
Lordship,
by some material which is available on record,
lordship.
barring the technicalities, I'm with you.
Lordship will kindly see technicalities, your lordship.
Let's
will-
come to the second charge then.
Lordship. Your Lordship, page 99, Your Lordship.
There is a customer saying that these were made unauthorizedly.
Lordship, that's what I am submitting, Your Lordship.
That complaint was not produced.
Complaint was not placed, Your Lordship. He has not made any complaint, Your
That is
Lordship.
why I'm saying the complaint letter PX nil, dated nil. There was a PX 24.
Lordship,
PX 24 was produced in the inquiry,
Lordship.
right? If a document was there and he himself was examined, Gogoi was examined as PW3.
I have taken a, Your Lordship, plea, Your Lordship. Why it is dated nil, Your Lordship?
Forget it.
Because, Your Lordship, these complaints were,
See,
Your Lordship, after the
Mr.
completion of the first
Mr.
inquiry.
Bhattacharya, we are not here beyond reasonable doubt. We are not here to determine beyond reasonable doubt. We are only on preponderance of probability.
Lordship, that's what.
Now that person, Gogoi, had come down. Show me his statement and your cross.
Lordship,
Gogoi's statement and cross.
Lordship, that will be with the record, Your Lordship. I don't have that, Your Lordship.
Okay, you might have given a reply against this.
Lordship, that reply I am giving Your Lordship. Your Lordship will get it, Your Lordship. Your Lordship, page 99, Your Lordship.
No. Reply to the inquiry officer's representation against the inquiry officer.
That. Your Lordship will get it at page 112. Allegation number 2. Your Lordship will see. The allegation is completely exposed the motive of the authority. It has been deposed by the complainant Monitor Gogoi that he was called to the branch to lodge the complaint. From the date of complaint, it is revealed that complaint was taken just after the further inquiry was ordered. That he was called to lodge the complaint has been deposed by PW1 also. It is clearly evident that PW3 has managed, witnessed, and arranged to collect further evidence in the further inquiry. Motive to further inquiry is clearly absent. The genuine withdrawals of ID use.
If that be so, if that there was a debit in the, see, that cannot be faked. That debit or credit that takes place nowadays online, you cannot fake it. It will be of that date only.
Lordship.
So if was of that date, there would be, if it was a genuine transaction, it would be, there would be some voucher, something on. Why did you not ask for that identified voucher?
Lordship, that's why, Your Lordship.
Identified voucher of Mr. Gogoi.
That's why, Your Lordship, I have requested to provide me the copies of all the.
And their reply is that vouchers are not there.
No, Your Lordship, they have produced, originals are not there, they are showing, Your Lordship.
Show me the voucher with pertaining to this Gogoi.
I don't have the vouchers, Your
No, in the inquiry you say it was produced.
Lordship, that Your Lordship will kindly come to. Your Lordship, these are the details, Your Lordship, page 88. Now, Your Lordship, I just want to pose one question to myself, Your Lordship. That, Your Lordship, assuming, Your Lordship, there are charges. Charges are, Your Lordship, very serious in nature against me. Will that, Your Lordship, will that mean that, Your Lordship, they will be allowed to, Your Lordship, go beyond the procedure laid down in law, Your Lordship, in conducting the departmental proceeding, Your Lordship? If they are very much serious about this, Your Lordship, they should have, what they should have done? They should have, Your Lordship, clearly, Your Lordship, take a, they should have prepared, Your Lordship, themselves with the documents, etc., everything, witness, and they should start the inquiry, Your Lordship. Why they are casual?
So your basic case is that the documents which they are relying upon,
Lordship,
which or they ought to have,
Lordship,
excuse me, ought to have relied upon
Lordship,
for establishing the charges not given to you
not given to me, Your
or
Lordship.
nor produced in the inquiry.
Lordship. And secondly, Your Lordship, will kindly see this further inquiry, Your Lordship. This further inquiry, order of further inquiry, Your Lordship. In the guise of further inquiry, Your Lordship, they have virtually, as it reveals,
A de novo inquiry.
de novo inquiry, Your Lordship. That power is not there with them, your lordship. Even if they wanted to go for de novo inquiry, what they should have done, your lordship? They should have, your lordship, at the first time, your lordship, discarded the present inquiry, your lordship, and then they could have issued a fresh so-called notice to me, and then, your lordship, they could have gone for this, your lordship. That they have not done, your lordship. And the further inquiry, your lordship, order directing further inquiry, your lordship.
How long were you in service of the bank?
Lordship, that, your lordship, I have joined, your lordship, in the year, your lordship, I have made a statement, your lordship. I was during the 87, your lordship.
So you are
10/9/87.
getting pension?
Lordship, say, removal, your lordship.
No. As per the settlement,
Lordship.
6A, memorandum of settlement, you are entitled. Yes, Mr. Talda. Even if it is a dismissal or removal, in terms of that settlement, 6A, whether he is entitled to the terminal benefits.
That was, so far the settlement is concerned, that is not my instruction.
Because the settlement says that in spite of this, if they have completed 10 years of service, they are entitled to.
That is their lordship, but so far that part is concerned,
Oh.
that part was not instruction.
Yes, Mr. Botagood.
Lordship.
Do you have any instruction on that?
No, I don't.
Because as far as I know, the settlement which is there, it provides that if you have completed 10 years of service, then you are entitled to the terminal benefit.
I will have to take
Take instructions. So this is basically your
This
case.
is my basically, and I am relying on few judgments on that.
Yes,
your
what are
lordship.
those? Can you just give me the list and the copies and the
Judgment I will
paragraphs?
hand over.
The paragraphs you just mark. Just give me the idea names.
One is your lordship, this KD Pandey, your lordship,
Hmm.
2010,
No,
2010 SCC
Hmm.
471.
Hmm. Then next one,
Para 5, your lordship.
you just mark it on top of
Lordship.
that. Then next,
Lordship, I will. Then your lordship, this is our High Court judgment, your lordship. Pujendra Dole, your lordship. Para
Chandra
6,
Dole pertaining to that
further inquiry, your lordship.
agriculture,
Lordship.
director agriculture.
Lordship.
Then
Panchayat, your lordship.
Panchayat. Okay,
Then your lordship, here your lordship, para 3 and 5.
just mark it, Mr. Bhatt.
Lordship, I am happy.
Yes, Mr. Talda. What is your,
And one more, just your lordship.
please,
Finally, your lordship, my argument will be, your lordship, while considering my disciplinary authority, while considering the punishment, your lordship, as per that award, your lordship, Shastri award, your lordship, the factors that is required to be considered has not taken into account, your lordship. That says, your lordship, if your lordship allows me to read it, your lordship, it says in awarding punishment by way of disciplinary action, the authority concerned shall take into account the gravity of the misconduct, the previous record, if any, of the employee and other aggravating and extenuating circumstances that may exist, your lordship. That has been considered in my case, your lordship, and the other judgments, your lordship, I am handing over.
okay. Basically, we'll have to decide whether that was a further inquiry.
Lords, that is.
Otherwise, the materials that are there,
Lords and your lordship.
I'm against you.
Lords.
But that issue will have to be. Yes, Mr. Talda.
Lordship, basic thing is that all allegations are actually not denied because of the user of identity.
What does your lord do?
Is there any circulars issued or the notifications made by the bank that this bank password an employee should not give to anybody else? Is there any norms like that? What are your points, Mr. Talda?
Allegations are not denied,
Denied.
basically. His personal ID number was used in the debit of the customer's account, for which the bank has to incur a loss of public money to the extent of more than 42 lakhs.
And what about his allegation that you have not produced or given to him the originals of the vouchers? Is it your case that the vouchers are not there?
Vouchers are not there, Lordship.
But then you have in the statements that I find of the witnesses, some vouchers were produced, Xerox copies.
That is, so far the evidence part is concerned, Lordship. In departmental proceedings, the evidences in a judicial review are to be not very. So far that part is concerned, in the admitted facts and circumstances, Lordship, it has lesser impact whether the original document or the Xerox copies were issued. The facts admitted otherwise also, even if we go by the rules of evidence, need not be proved. That is another aspect.
No, your case is simple. Your ID was used,
Yes,
so that's the end of the matter.
that is the end of the matter, and he has not denied it. And he has been actually inducting some other person vaguely that some other person is involved.
So that's why I asked him that
Yes,
who is
yes.
that other
Who
person?
that other
Identify.
person is, who is, or who has used his ID number. And in all the cases, Lordship, the same method, the modus operandi was all the same. Both allegations are as done by same method.
Got it.
Allegation number 5 is, Lordship, that is the cumulative.
That is
thing.
just a-
That is just an accumulation of allegation 1, 2, 3, 4. That is what is my case, Lordship. For the purpose of so far the bank official is concerned, Lordship.
Okay. Mr. Bhattakur, just whatever you have said, more specifically with regard to that further inquiry, can you just give me a 2-page note?
I will. 6 or 7. Para.
So
Ah,
in my
huh.
affidavit, para 9 has also admitted that further inquiry was conducted. It is not denied
Hmm.
for some reason.
Hmm.
Lordship,
Was an inquiry report available at the first place?
first inquiry
Ah.
report, Lordship.
What is your stand on that?
Lordship. I am giving it, Lordship.
The affidavit, paragraph 9, page 3, internal page 3.
Lordship. That is, we have not suppressed this fact. It is
No,
not.
my question is, had the inquiry officer presented an inquiry report before you at that stage?
First report,
Ah.
Lordship, I have got with me.
Huh?
I am.
There was an inquiry report.
Lordship.
Thereafter, further inquiry was there.
Yes, Lordship. That is there. The first inquiry report.
Huh? In the first inquiry report.
That's the end of the.
Because that you have not brought that aspect of the matter even in your affidavit, not disclosed.
So that part is concerned, Lordship, after the further inquiry was held, first inquiry report, further inquiry report.
No, I got it. That
Yes.
at least
Party-
to
party-
say that things in Seritam
Lordship.
as a bank, as a model employer, you should have disclosed that there was an inquiry. However, the disciplinary authority, when it got the report, there was you are within your rights to have a fresh inquiry. Or not, sorry, fresh inquiry, further inquiry.
Further inquiry.
That Supreme Court has also said that is permissible. But
Okay. Yes.
what was the lacuna found?
So far the affidavit is concerned,
It's not here.
that is not there.
It's not there. That's why I was having a doubt.
However, I have been furnished later on, Lordship,
Hmm.
that report also. When
And
the-
that report we don't want. What is the decision of the authority based on that? Other than this letter?
Oh,
That letter issued to the petitioner.
if your Lordship permits, I may be given some time to have instruction and place it before your lordship.
No problem. No problem. Just
So far the.
because that letter which is there for further inquiry issued to the petitioner, that you will find that
Page 95.
90?
Five.
See, second line. What was these areas that were identified? Just get a clarification on that.
If I am to your lordship draw analogy from the CRPC, your lordship, the power of further inquiry, your lordship, they are also your lordship, they will have to point out the lacunae.
That's why I want to see it, what it is. You give me your note.
Lordship.
When, Mr. Talda? When?
I'll get it.
When? When should I fix it? Huh?
Cleared. So after vacation, lordship,
Before vacation.
before vacation.
Let us have it on. I've heard it. 27th. That will be fine. Or 25th, whenever it's convenient to you.
Just let me check.
27th.
27th.
All right, lordship.
Mr. Talda, if possible, you also give me a note. You also give me a small note for my guidance. That much only. But this issue just
For
address.
27th, I will try to.
I will hand over the copies along.
You just take me out of the objections taken by Mr. Bhattakur. I'll dismiss the case. Because I am convinced once that ID, he has got no explanation. That's the end of the matter. But he has
So
taken
the
some
procedural
pertinent
part is
piece.
concerned, he is on that, my learned friend is on that.
And naturally, he will be on that. So
Lordship.
those two aspects just take me out.
So
Show
for-
me
so
that
for
why,
application-
what
so
was
for-
the application of mine for that further inquiry?
Lordship. Appreciation of
number.
evidence is actually outside the scope of review.
We'll
That
not
is-
go.
That is not there.
What is there, I'm satisfied.
Once
But
national
this-
justice is
this-
followed.
No. This aspect, why you require, see, to
Yes,
cover up
Lordship.
lacunas, you
I
cannot
will
have
get
a
it
further
clarified.
inquiry.
I will get it clarified, Lordship, and I will.
That'll do. Otherwise,
Lordship judgments, I will hand over, lordship, along with the note, your lordship.
that note together.
Deeply
Yeah,
obliged, your
that cases only I'll have to refresh once, that's all.
lordship.
You see that Kakkar's case also,
I
PC Kakkar. A loss of confidence, you
Lord.
write loss of confidence, you will get it. Very strict.
Lordship.
Ek number to material. Ek number. No, it's okay. Oh, was it communicated?
Yes, man, it is part of the writ petition.
Oh,
Page
where?
23.
Yes, Mr. Kotogi.
And these remarks, my lord,
Hmm.
lordship may tally with page 123. Whatever has been communicated. my lord.
123 means that
Yes,
copy of the
yes,
report.
yes.
120?
3. First is, my lord, usually non-cooperative.
Yes, Mr. Even if we direct, because that copy is with you, you have not asked for a review of that.
Not copy, Milord, that is assuming that is a communication, I accept it. Now the question is, Milord, my case is here, Milord, I'm on, that there are criteria laid down by them.
Let us deem that there was a vacancy and you were deprived. Now, in view of this,
No, my lord, this, there are, according to their own memorandum of understanding, 3 years ACRs are taken for counting the marks.
show me that criteria.
Exactly, my lord, I am coming is. Their own circular, my lord.
Page 70 says 2.4 in the event unsatisfactory confidential report during the preceding 3 years pending disciplinary action, undergoing punishment or any vigilance case in respect of the workman in grade 8. The eligibility for movement to grade 9 for such
Your
workman
lordship, kindly turn to page 56.
56. Okay. Hmm.
1.1.2. Down below,
56
56.
of the
Oh,
petition.
yes, it is, my lord, running page will be.
Okay, okay, I got it. 1.1.2.
1.12,
Hmm.
Roman 2, my lord.
Hmm.
This is CR mark. Outstanding 40,
Satisfactory.
Above satisfactory 35, satisfactory.
So you
20.
must
Average-
have 40 marks. You must have 40 marks.
I have to mark get 40 marks.
Hmm.
If your lordship see the my ACR,
Okay, Mr. Kotogi,
outstanding, page 132,
outstanding 40.
outstanding 40,
Hmm.
1 year satisfactory,
Hmm. Satisfactory 25.
25,
Unsatisfactory no marks.
unsatisfactory.
So
no.
now 0. Now if you take the average of this 3, it will come below 40.
22.5.
22.5. That is the beauty when you have somebody good in maths like Mr. Deka.
Hello, correct.
So this 40 marks that you have to get, you are not getting.
That will be counted while taking interview.
That is the eligibility criteria. You must have this 40 marks. Personal interaction
No,
knowledge is 10 marks.
Eligibility criteria is not 40 marks. This is the weightage given in the hearing.
I got it.
My lord, eligibility criteria will be governed by the circular. My lord.
Show me that. Show me that. Yes, you're right. This is weightage.
That is that page your lordship kindly see. I may be disqualified in the interview, 27.
No, where is that circular? Yes, Mr.
27, my lord.
It is the 511.92, my lord.
Page 40, your lord. Kindly
Page
turn.
40.
Yes. As your lordship, H. In the event of unsatisfactory continuous disciplinary action or any vigilance case in respect of an
Wait,
eligibility for promotion of
Mr.
such an
Kotogi.
employee
Mr. Kotogi.
will be
System.
governed by as per the company's criteria.
What is that? What is that you are reading? What is
Page
that
40,
document?
my lord. Running page 40, clause H.
Running page 40.
Running page 40.
Clause H.
H.
As per existing company policy in this regard.
In this regard, my lord,
What is
policy,
that policy?
policy will be go. There is no such policy I have gone through. I mean, I have found it from the pleadings. My lord, therefore, we have to.
There is a personal manual, my lord. This is an extract which says, my lord, promotion involves a movement from a post in the lower grade to a post in the higher grade. Employees are eligible for consideration promotion within the same cadre/discipline on completion of the prescribed period and attainment of satisfactory standards in conduct and performance. So the yardstick, as in the last affidavit, my lord, he has to attain a satisfactory, my lord.
No, below
That is weightage. Where is the bar?
bar.
That if you have an unsatisfactory ACR, you're not considered.
As such.
Because you're that
absolute bar.
affidavit, no, you're that affidavit that you have filed subsequently.
This is, I'm relying on this one. That you have to attain satisfactory in conduct as well as in performance.
2:1, my lord. One.
See, you have given weightage 40 marks,
Wow.
right? It cannot be the minimum.
It is not the minimum.
It cannot be the
Cannot be the
minimum.
minimum.
So only thing is that if he does not get, if he gets 22.5, his rating would be down.
My lord, 22.5 is not even prescribed, my lord. 25 is the minimum. That is what
Where?
I own, my lord.
Where?
There itself, my lord, at page
Where?
85. Page
Where?
85.
Where?
When we are assigning weightage, my lord. Running page 85.
Come.
CR marks is 40, my lord.
CR marks is 40.
40.
Why I am telling you? You get outstanding for 3 years. You can't get more than that.
You can get more than.
So that will be average 3 years, 40.
It's written, my lord, average of last 3 years rating shall be considered as existing.
Existing. So now
Existing.
this 40 in his case would be 22.5. Now by taking it as 22.5, where does he stand?
What I am on my lord.
Mm.
We can take it as 22.5, then a recalculation will have to be done.
Mm.
What I am on is, my lord,
Mm.
the minimum prescribed here is
You
25.
come to next page.
Yes,
Qualification marks.
yes.
This is that educational
This is
profession.
educational qualification.
Okay. So sum total of this, you have not said that you must achieve this much.
No.
No, we have not said.
Then
Then
We have not said. But in a criteria, we say that if it is unsatisfactory in the main clause H, my lord, which my learned friend.
he'll not get marks.
He'll not, no. He will be considered as per the governed by the existing policy. Existing policy says, my
That
lord,
cannot be brought in, Mr. That cannot be. When you have now see the existing policy is this. This is the way you will assess a person. You have not said that see if you have an unsatisfactory ACR because he has an
There is no-
outstanding.
even-
Thereafter, he has an outstanding one.
even in this, my lord, even in this, there is no absolute bar. It does not say. I have to be fair to your lordship, my lord.
It does not.
It does not.
Cannot.
It says, it
So-
could have, my lord, it could have prescribed that if you fail to achieve a minimum satisfactory performance, you will not be considered. It
Fine.
could have said.
We would that would have been the end
could
of
have
the
said.
matter. Mm.
my lord, criteria always formulated on the basis of policy. Your lordship, if your lordship have to look on page 27, my writ petition.
Mm.
How they can go beyond that? Huh? 27, has your lordship got it? Page 27, circular, application are invited through proportional from eligible workmen in grade 3, so meeting the following criteria. Meeting the following criteria for the post of officer grade A in the following department. The applicant should have completed 4 years service. The employee should not be undergoing any punishment. Employee deserves, these are only 2 conditions, my lord. 4 years. These are the policies of the department.
And in fire, there was only one post.
Probably.
And the private respondent has got it. Right, Mr.
Yes.
What is his marks?
On 78 point something.
And what was the marks of
No, he was not calculated. He was not considered.
not even
Now, because he was rejected on some other ground, my lord, not on this. Because now if we consider, my lord, that 10 marks is there, which is for
10
the-
plus 20.
No, 20 is fixed. Whatever is his qualification, he will get.
Get it? So if
So
it that
for-
10 marks,
For
he
20,
gets
20 CR marks as well as for the first experience, my lord, there is no subjective satisfaction.
that is
Whatever is
fixed.
there is there, he'll get it. So the 10 marks, how much does he score there?
Mm. So, Mr. Deka,
My lord,
what is the marks that he would now stand with regard to that subjective satisfaction? Oh, no. The objective one, seniority fixed,
72.5.
Huh?
72.5.
he gets.
I had made that calculation on
Okay, 72 point.
5.
And how much did the private respondent get?
He got 78.33, I think. Just let me check.
So this is minus 10. 72.5 is without considering 10.
Yes, without considering.
So now if 10 is taken into consideration, he may score a match.
He may. But that is, that again, and he has to face an interview.
That he will have to.
That he'll have. He had scored 78.3. But since that is not a part of the record, my lords.
No, we'll not make anything which is not a part of the record.
Lordship will record my submission, but my submission, my stand in the affidavit is that because of that unsatisfactory, he is not eligible to be considered. And even if he's about that, 22.5 has to be considered.
Okay. Anything more? I'm required to reformulate the thought process for me, myself now in this matter. Earlier we were on a different footing. Now we have come to a different footing. Anyway, no problem.
That is the thing of reputations. Had it been a civil suit, my lord, I would have contended no,
It will
you
not.
cannot. But it's a reputation, my lord. Okay.
That I just took for my satisfaction, nothing. Mr. Kotogi, you give me a small note. You also.
Well.
And if possible, therein bring this marks on record. If possible. If permissible on your part. Otherwise, don't need. I'll do it. I'll. That would be a camouflage thing. We will pass orders if we come to that. But please touch on that cluster thing also.
Yes.
Somehow I have lost sudden connection. I'll have to just go back to the video.
By Tuesday, I can give my lord.
Tuesday, Wednesday, no problem. Wednesday.
Tuesday or Wednesday. Lordship will list it.
Wednesday, I'll list it.
I will.
Begin. As agreed to by the Learning Council for the parties, list this matter again on Tuesday, 18 for further hearing.
18th.
18 further hearing. Just only for that purpose. And any decisions you are relying on, you can give me also that. But don't give me anything abstract that this is the, we don't want that. Factually covered. Yes, Mr. Hello, anything you have to say? Nothing. You adopt what Mr. Deka is saying.
Item 4.
May it please your lordship. Lordship, my senior is having viral fever and he is on bed. So kindly the matter may be fixed after the vacation.
No, sorry.
Sorry.
Sorry. 2015 matter, we are not fixing it. He's not well, we'll have it next week, next Tuesday. But if you don't do it, we will pass orders. It's with regard to equalization of pay. I've gone through it. Have anything to submit, you can submit. It is stated that the arguing counsel is indisposed and accordingly a prayer is made for listing this matter again on 19. So prayer accepted, list this matter again on 19/6/2024. Mr. R. Barpujari and Mr. R. Dhar, along with Ms. J. Das are present for their respective respondents. Yes, Mr. Barpujari, you've gone through?
In fact, they are also relying on a obvious memorandum issued by the finance department. It is for them.
Now to demonstrate that later part, how this covers them.
It will only point up to that issue.
Item 6.
Yes, Ms. Ghosh.
Lordship,
Hmm.
petitioner is seeking retrospective benefit of the post he was serving. Lordship.
Yes.
December is on, he's out of station, my lord. No, my lord.
Why? Why yesterday note was not given? Even today morning.
Today I came to know, my lord. Actually, he's out. That was the instruction.
Next time, I'm not going to permit this. Yes.
My case is that Lordship, the petitioner is seeking retrospective benefit of the post he was in charge and he was serving.
Show me. Show me how you can be given that.
Earlier, so with that regard, he has filed a writ petition earlier, Lordship, and the honorable.
Order is there
Yes, Lordship, order.
for
is there.
representation disposal.
Yes, Lordship.
Representation disposal.
Yes, Lordship. And with that regard, I have given representation.
There are
on-
two posts involved in the fray. Development officer, district officer.
Yes,
So you want to have both together. Right? That is the case.
yes. I was working in.
I know,
this.
both together. Now you want both. The promotion should be literally to two posts now.
Yes,
When? We'll have it on Friday. Friday.
this Friday.
You are not here.
Can it be on Monday,
Tuesday.
Tuesday? Lordship?
Tuesday.
Lordship?
Tuesday.
Much obliged.
Yes.
As prayed for by the parties, I'll list this matter again on Tuesday for further hearing. We'll see on that day.
Yes, Lordship.
Just satisfy me
Yes.
how you
Lordship.
can come in. That's all.
Yes, Lordship.
In that narrow area.
Yes, Lordship.
Okay, after some time,
Why?
my senior is on outside, let me call him.
Huh?
My senior is on outside, let me call him.
Who is your senior?
Mr. Dewar.
Okay. Yes, Mrs.
I'm appearing for Water Issues Department.
These people have not been given the benefit of Upendas also.
If I am handicapped today, I will have to brief you.
Because Upenda's decision came to be, my lord, pronounced at a later date. Perhaps,
Be that as it may.
but here in this petition, they are seeking absorption. Now, in view of Upenda's, my lord, perhaps it will not be permissible in view of paragraph 22, 23 is categorical. Lordship is aware.
Show me. After Upendas division bench judgment, how can I go back?
But my lord, similarity is shifted with persons.
Show me.
We
When?
have regularized, my lord.
When?
We have annexed a copy, my lord.
When?
In my reply.
A reply. Yes, reply.
My reply, affidavit in reply against the respondent number 1,
Okay. Page.
page 13, annexa P,
This is of 95.
my lord.
Right?
And Chennai does,
Right? 95.
95, my lord, but
Huh.
please.
I am also saying people were absorbed. But after the decision of the Upendas,
And
how
my
can
lord,
we?
lordship may kindly peruse annexa B of the writ petition,
Annexure B.
page 26. The name of the petitioner number 2, my lord, Julian Chandra, Pradeep Datta, Chennai, Borneo.
This is work charge establishment, no problem. You will get the benefit. Yes, Mr. They'll continue to get that scale work charge. As per Upendas also, there is a circular.
Yes, after Upenda's, my lord, perhaps it is 3rd of October 2019.
they will continue to get that work charge scale also. They are getting a scale, you are getting a scale of pay. Work charge,
No, my lord.
fixed pay.
Fixed pay, my lord, but I am, no termination order was issued, my lord. I am not in my job.
You are not in your job now. From when?
From, my lord, 92, my lord. They have to also contribute at our names were also.
My lord, perhaps.
Our names were also
What has
forwarded,
to be,
my
my
lord.
lord, in
Show me
one-
how we can now protect your interest.
My lord,
92, you are not in service.
From the year
Mr.
2000.
Mr. Bora, be careful when what you're submitting. You said from 92, you are not in service. Yes or no?
My lord, from 92, my lord, they have not engaged me or
That-
not issued any letter, my lord.
What I said like this. What
Right.
you are saying like this. But
Well,
it's
I
the
have-
same thing.
I am not.
It's the
not-
same thing.
I am not,
It's the same thing.
I am not in the job, my lord.
Not in the job. From 92 to 2015, explain why you have not come before this court.
I am, since then, I am fighting a high court case, my lord.
Okay. Show me the
All
last
the
one.
orders, my lord.
Show
And
me.
my lord, I have to.
No, show
mention,
me,
my lord,
show me,
my
Mr.
lord,
Bora. Just clarify that.
My lord, prior to that, my lord, let me submit, my lord.
Mm,
Petitioner number 2 died in the year 2022.
mm. Substitution not done.
A substitution not done, my lord.
Very good. Then
I have informed, but they have not.
forget it. We are only concerned with petition number one now.
One.
So show me the earlier orders of this court.
My lord, Annexure 1, page 41, my lord. My first WPC one.
Prolokko Borua. Page 41.
40 order starts from 40, my lord. Dated 23
8960.
8960 2005.
Then what happened?
Then, my lord, we have filed contempt case, my lord.
Then
My lord, in the contempt case, my lord, communication was made by enclosing the order dated 7/11/07, Annexure M, page 48.
then
And my lord, for that, my lord,
mm,
lordship may kindly again our reply, take up our reply, my lord.
then they passed an order
Passed an order, but
47.
that contempt order was passed.
Fine. They have disposed of your representation saying that you are not fit for
My lord.
regularization. Fine, no problem. Then what happened?
Then, my lord, we have again came before this court, my lord, by filing WBC, present WBC, my lord.
Now this is under challenge.
My lord.
Okay.
And we have stated in the reply, my lord,
Okay. Then your reply, what do you have stated?
my lord, in the reply, para 3, my lord, lordship may kindly review para 3. How the said order was communicated to us.
Hmm.
Para 3, my lord.
Mm.
Prior to giving reply to the your lordship's member. Contempt order was passed on 24/1/2014. And I have stated that no point of time long back from 7/11/7 to 5/5/2014, neither one of the petitioner had received the said
That order. Okay. Now, this order was passed in response to an order dated 23/12/2005 in WPC number 9860/2005, right?
It was also a typographical mistake, madam, on WPC number 8960.
It should be 8960.
Madam.
And the order is of 23/12/2005. Okay, this is a typographical error.
Page 40 and 48.
Hmm. Now, how was this contempt petition of 2008 instituted against an order which was passed in 2005?
Madam, no, we have filed, contempt just filed earlier.
2008.
Contempt just filed 2008. 176 of 2008, filing declaration.
And why was this order 7/11/2007 not communicated?
They have to reply, madam. Or show any proof, madam. Whether they
Where
have-
is your statement in the writ petition that this was not communicated?
In my reply, we have.
Not in your reply, in your writ petition.
While we have made inquiry, my lord, then we have came to know, my lord. And that state order has been posted to us, my lord. With a letter from the office, my lord.
Okay. Yes, Mr. Barbujari.
No, page 48 of the writ petition is precisely what has been put to challenge here. Page 48. What I find from the prayer portion at page 17 of the writ petition, page 48. Now, page 48 speaking order has been passed, my lord, by the authorities of the Water Resource Department on examination of facts. Kindly, my lord, come to the last paragraph at page 48. There is a categorical finding. In the instant case, the casual laborers were disengaged on 30/9/1985, and hence their case do not fall within the purview of the said government direction, and hence their service could not be regularized as claimed. So there is no continuity in service. And even if my lord Upendas is
No, it will not come in.
yes, because Upenda one has to be in continuous service from 8/6/2007, because the judgment was passed on 8/6/2017. Turning the clock back, we have to move down, my lord, for 10 years. It will start from 8/7. So admittedly on 8/7/2008.
Mr. Bora, you have taken me through some,
Not in service.
you have taken me through that pay thing. Where was it?
My lord,
Pay.
we have enclosed our pay vouchers, my lord.
85.
In reply, my lord.
85.
14 and exactly.
85. Page?
Page
Reply?
14. And exactly
In your reply?
in your reply. my lord.
Okay. This is for which month?
So the month it is not. Which one? Yes.
March 92.
My lord.
Show me something which will establish that you were working till 95? Just show me something.
My lord, a forwarding letter, my lord,
Where?
Annexa B.
To whom it may concern?
No, my
No,
lord.
Annexure B.
Right.
Okay, this is 91.
My lord. And they have said they up to 92, they have okay. Yes, right. Annexa D, my lord.
D.
D, page 29. It is dated 20/11/92. They have directly forwarded the application for consideration of as a appointment.
It goes against you. Okay, can't help it. Heard Mr. D. Bora, learned counsel for the petitioner, also heard Mr.
And my lord, I have a submitted Supreme Court decision also.
Which one? Name?
My lord, 2016 1 SCC 521, Vice Chancellor of Lucknow University, and versus Akhilesh Kumar Khare and another one.
Show me.
Nasuda kindly directly peruse para 11 and 19.
Heard Mr. D. Bora, learned counsel for the petitioner, also heard Mr. C. Sharma, learned standing counsel, Water Resources Department, appearing for the respondent numbers 1, 2, 3. Also heard Mr. R. Pujari, learned standing counsel, Finance Department, appearing for the respondent number 4. The petitioners, by way of instituting the present proceedings, have presented a challenge to an speaking order dated 7/11/2007, by which they pray for being re-engaged in their service and as well as for a regularization of their muster roll / work charge services came to be rejected by the appointing authority, holding that their such prayer were not covered by the policy of the government in this connection. Full stop. The petitioners in the present petition content, full stop. At the outset,
Petition number 2 died.
at the outset, Mr. D. Bora, learned counsel, submits that the petition number 2 herein had died
Died in
during
the year 2022.
year 2022. However, his heirs have not stepped forward for substituting themselves in the present proceedings. Accordingly, he prays that the present petition be limited to the petition number 1 herein. Also, the petition number 1 was initially engaged as a chowkidar cum casual worker via an order dated 17/85, and his such engagement in terms of the order, said order was to continue till 31/8/85. It is seen that the petitioner services were engaged from time to time. However, there is nothing available on record to demonstrate that the services of the petitioners were so engaged after 1992. So, the forwarding dated 2011
A4, my lord, page 25, my lord, and extra A4.
then this forwarding is wrong. Okay, after 1992, will equated here, huh? After 1992. So, a forwarding dated 2011-92 was brought on record by the petitioners to demonstrate that the applications as made by them were being forwarded by the executive engineer, North Lakhimpur E&D division, to the government for consideration of their prayer for re-engagement and regularization of their services. The said forwarding also notes that the petitioner number 1 had worked as a master role worker from 1985 for 4 months and thereafter during the flood period up to 1992. There is no material available on record to show. Full stop. The petitioner's content that petition number 1 contents that he had approached this court by way of instituting WPC number 8960/2005 and this court wide an order dated 23/12/2005 was pleased to dispose of the said petition with a direction that the respondent authorities shall consider the case of the petitioners and engage them as muster rule worker and to consider their case for regularization in accordance with the existing rules, guidelines, etc. In the said order also, it was noted that the petitioners herein were working continuously as muster roll worker. Petition number 1 herein was working as continuously as a muster roll worker till 1992, and thereafter it was recorded that they were engaged from time to time in the Water Resources Department. Also, the order dated so and so not being complied with, the petitioners had instituted contempt case being contempt case number 176/2008, and this court wide order dated 24/1/2014 had disposed of the said contempt petition, extending the date for consideration of the grievance of the petitioners in terms of the said order dated 23/12/2005 passed by this court in WPC number 8960/2005 by a period of further 6 months. Also, the petitioners contend that after the passing of the order in the said contempt case, the respondent authorities had wide communication dated 5/5/2014 forwarded to them speaking order dated stated purportedly to have been filed, to have been passed on, to have been issued on 7/11/2007, wherein the executive engineer, North Lakhimpur WR division, had proceeded to reject the case of the petitioner. Post op. It is this speaking order dated 7/11/2007 that is presently under challenge in the present proceedings. Post op. I've heard the learned counsel for the parties and also peruse the materials brought on record. A perusal of the order dated, speaking order dated 7/11/2007 would reveal that the case of the petitioners herein for regularization of their services were not favorably considered on the ground that the services of the petitioners came to be terminated, discharged, disengaged on or before 24/1995, and accordingly it was contended that the policy of the government in place pertaining to regularization of services or work charge muster casual employees mandated were engaged prior to 1/4/1993 mandated that such workers were not disengaged, terminated, or discharged from their services before 24/1995. Subpara. The petitioner in his pleadings has not brought on record any material to demonstrate that the petition number 1 was in service as of 24/1995 and his services were not so terminated prior to that said date. Full stop. The case of the petitioner not being covered by the policy pertaining to regularization of services of muster rule oblique work charge employees engaged prior to 1493 as adopted by the government in the matter, this court is not in a position to direct for consideration of the case of the petitioner for regularization of his services in absence of materials being brought on record that the petitioner, after being engaged prior to 14/1993 on work charge oblique muster rule basis, had continued to remain in service after 24/95 and thereafter. Also, in view of the above conclusions, the speaking order dated, in the considered view of this court, the speaking order dated 7/11/2007 does not require any interference, and the petitioner having not been able to bring on record materials justifying their continuing bring on record materials showing continuance by him in service after up to 24/1995 and thereafter, the writ petition is held to be devoid of any merit, and the same accordingly stands dismissed. However, there would be no order as to cost. Sorry, Mr. Bora.
My lord, regarding the compensation part, my lord, we are before the Honorable High Court, my lord, fighting our cases, my lord. And one person also died, my lord, which number 2. I have so that
No prayer here.
I have so, my lord, in my reply, my lord, I have
Reply
stated-
will not do. In your writ petition, there has to be a prayer for
My
compensation.
lord, that is the alternative remedy, my lord. If court can do,
You,
my lord,
you,
court can
you
do-
go wherever you want. If there is a scope for getting compassionate or compensation, please have it.
My lord,
Please have it. Please,
have
please, please
I have
explore.
relied upon that judgment, my lord.
This will not help you. You
Because
can test this. You can test
I am
this.
fighting the case, my lord, since 2005 and still.
You
no
have a
judgment.
big building. You have built up a big castle, but the foundation is not there. Can't help it. Small earthquake takes it away. That's the problem. I'll have to have some legal.
And my lord, see, my lord, one petitioner also died, man.
Can't help it. Can't help it. Can't help it. My sympathies are with you, but heart goes with you, but mind goes with them. Can't help it. Next time. Yes, Mata.
I'm obliged.
Yes.
We have filed our detailed lordship.
Oh.
Revenue is a transfer subject to the PC lordship, so we already engaged in lordship as per advertisement lordship.
What is there? Any interim order?
No,
Training complete?
as per our affidavit in first case lordship,
Hmm.
training also completed. And first is not for training, it is appointment lordship,
Appointment.
already appointed.
And the second one?
Second one is training.
593 is training.
First one, 593 is appointment, I think. Since revenue is transfer subject to BTC, DC has no role to play lordship. They are challenging that part only lordship.
%89 appointed.
Appointed as per our affidavit.
They are not made party respondents here. And this one, training, that advertisement was issued, training completed, leading to these appointments. That's the case.
Training is just for
I know that.
precondition.
Non appears for the petitioners on call. Also. দুটা আছে দেই বেলেগ বেলেগ order. Consider Ms. R.B. Bora, learned standing counsel, PTC is present. In view of the above, the writ petition stands dismissed for non-prosecution. A dutate beleg beleg order. Nothing is there. 15, everything has.
Item 10.
Higher tasks in the side. Yes, Mr. Dury.
Lordship, I was awarded the punishment of censure after the departmental proceeding. There it was, order was reviewed, and one increment was withheld.
What happened?
My lord,
With cumulative
we
effect.
somehow, my lord, missed to file the affidavit. I just took out the file, my lord, and saw that the respondents, they have wrong back. They have sent an affidavit. This
Hmm.
must be brought before, my lord, why that review was done, my lord? That part. Why the Inspector General of Police has. gone
Yes,
for the-
where is your penalty?
Page
Hmm?
page 33, your lordship, the order. The reviewing order, may I read, your lordship? Page 34 is the operative part. After perusal of all documents and orders, I agree with the observation of Honorable Assam High Court Commission. I, being the reviewing authority here, I review the earlier order of Senior Superintendent of Police Guwahati City issued by DO number so-and-so dated 1/8/2011 and award the punishment that is with holding of ASI offender summers 1 increment with cumulative effect.
Where is the notice given to you prior to this?
No notice was.
No notice. Where is your statement?
Prior to this. The
Where is your statement to that effect?
32, your lordship, departmental proceeding, your lordship, may kindly see the order.
Huh?
32. The
No, no,
order-
no, no. I want this order, 39/2013,
Yes,
reviewing the order,
yes,
enhancing the penalty.
exactly.
Where is that statement that no notice was given to you?
Paragraph number, paragraph number 13, your lordship. 10, may I read 10 also, your lordship, 10. Then the petition, may I read, your lordship?
Yes, that will. Yes, Mr. Duff. What remains? He is finished. You sit down. You submit. Yes, Mr. Duff. Hmm. Hmm. The authority can review, there is no problem, can enhance, but the requirement is notice.
That notice is not there. now.
That's the end of the matter. Where is the order? Disciplinary authority's order.
Page 32, your lordship. There you go.
No, no, no. 2/8/2012, right?
Two 2012, your lordship.
Hmm. This disciplinary appeal rules only will apply here also, police. Same thing. Huh?
I have just checked the draft affidavit, madam,
Hmm.
that I have. That-
Fine. Also, heard Mr. T. Diori, Learned Counsel for the petitioner. Also heard Mr. R. Dhar, Learned Government, Additional Senior Government Advocate appearing for all the respondents. Also, the petitioner has, by way of instituting the present proceeding, presented a challenge to an order dated 3/9/2013, passed by the reviewing authority, enhancing the penalty imposed upon him by the disciplinary authority on conclusion of a departmental proceeding instituted against him in the matter. Also, basing on the allegations so level against the petitioner, a departmental proceeding being DP number 18/2007 was so instituted against the petitioner. Also, on conclusion of the inquiry and submission of the inquiry officer's report and the representation made thereon by the petitioner herein, the disciplinary authority proceeded by order dated 2/8/2012 to consider the matter, and on such consideration proceeded to impose upon the petitioner the penalty of censure, and along with a warning not to repeat such conduct in future. Full stop. The matter ought to have ended at that stage, inasmuch as the petitioner did not prefer any appeal in the matter against the same. However, it is contended in the writ petition that after lapse of around a year, the petitioner received the copy of the impugned order dated 3/9/2023, by which the reviewing authority, that is the Inspector General of Police bracketed CWR or Sumoto, had reviewed the order passed by the disciplinary authority in respect of the petitioner and proceeded to enhance the penalty as awarded to the petitioner by replacing the penalty so awarded with a penalty of withholding 1 increment with cumulative effect. So it is seen that a major penalty came to be imposed upon the petitioner in the matter. However, what is to be noticed is that the petitioner was not present was not afforded an opportunity of hearing before the enhancement of the penalty against him in the matter was so decided. Before the penalty imposed upon him in the matter was so decided to be enhanced. Also, it is settled law that for enhancement of any penalty by any authority in the hierarchy, the delinquent must necessarily be given an opportunity of hearing in the matter. Full stop. In the present case, a perusal of the impugn order dated 3/9/2013 reveals that the same was so passed without even providing an opportunity of hearing to the petitioner in the matter. No notice seems to have been issued to the petitioner by the reviewing authority in the matter. Full stop. In view of the above, Supreme Court of judgment did it. In view of the above, and also applying the decision of the apex court in the order dated 3/9/2013 in the considered view of this court cannot be sustained, and accordingly the same is set aside. Full stop. The penalty as imposed upon the petitioner by the disciplinary authority by order dated 2/8/2012 shall remain to hold the field. Full stop. In view of the above, the writ petition stands allowed to the extent indicated herein above.
If you have There was an earlier stay order, Your Lordship, on.
The interim directions passed, interim orders passed in the matter stands by order dated 6/2/2015 stands merged with this order. Not hearing.
It's
Now getting.
now.
Some problem is there.
My lord, will just give the observation that the authority is at liberty to further proceed with accordance with law, my lord.
Say, you have not proceeded in the matter on your own. You're proceeding in the dictate of somebody else. How can that be? It may be anybody. It may be this court also. But when it is departmental proceeding, it's your own view. You have not taken our own view here. I've seen that.
Deeply.
Right?
Human Rights Commission, my lord. So.
Huh? No, I'm not on the commission. Even if the commission says, or any authority says, you have to arrive at an independent conclusion. Right? Which is absent. That's the first thing I saw. Yes, Mr. Soma. She has, I think, accepted your talaknama. Huh?
Because he is the second wife, the husband number 4 is the second wife of the deceased minor. After divorce of the first wife, she was married and she has received all the pensionary benefits.
No, they are not here. Why are you worried?
Hello?
They are not here. You are
Yeah.
for the respond number 4. None appears for the petition.
So from my knowledge, the marriage in fact, petitioner has died by this time.
Maybe that's why they are not here. We'll not put anything on merits. Heard Mr. None appears for the petitioner on call. Heard Mr. K. Sharma, learned counsel, appearing for the respondent number 4. And Mr. A. Deka, learned counsel.
On behalf of SS Roy.
Mr. S.S. Roy appears on for the CGC appears for the respondent number 1, 2, 3. And Mr. K. Sharma, K. Sharma, learned counsel, appears for the respondent number 4. What's up?
Respondent 4.
Respondent number 4. What's up? In view of the above, the writ petition stands dismissed for non-prosecution.
Right.
May I please, Your Lordship? Lordship, kindly adjourn the matter for today, Lordship. My senior, he is out of station, Lordship. Lordship, next week,
Who is your senior?
J.K. Goswami, Lordship, standing counsel, Apex Bank.
When did he go?
Lordship, today, Lordship,
Today.
morning. Lordship.
So he knew about it yesterday that he is going.
No, Lordship.
Why was the matter not brought to our notice?
Lordship, today we received the report, Lordship, from
That's a different thing altogether. You have the record with you. Fine. Only the suspension period.
Yes, they impose censure, my lord, but the period under suspension, my lord, they treated is
And what is the nature of the promotion?
promotion, my lord, already see retired.
Retired. Only the suspension. What is the length of the suspension period?
It's from 2897 till, my lord, reinstated.
Mm.
5/6/2000, my lord. 2897 to 2000.
2006.
2897 to 5/6/2000.
5/6/2000. Where is that impugn order in after the directions of this court?
After the direction of this court, my lord, include
11.
page
31.
31.
Mm. They have not said anything about the suspension period here.
Because of earlier decision in 2000,
Where is that decision? Just show me
there
that.
is annexed, my lord, a
18.
page in affidavit, my lord, filed by them. Page,
That is what I'm saying. Page 18. And then what is the order?
no, that resolution was annexed, my lord. Order was.
Okay. Yes. So, what is the error there?
Look, my humble submission.
You were not, maybe the penalty was toned down, but you cannot be held to be not blameworthy.
Because charge number 1 was full. That's right, you know. If you look, go to their rules, you know. 46(1)(a), censure, punishment. And 46(1)(a), censure can be maybe imposed without any defeat. If you go to the rule 43, you know, power of suspension on contemplation of departmental policy.
But Mr. Kotogi, here the penalty is after a departmental proceeding.
After the
So
department-
that provision of 46 will have to be read in the facts of this case.
I mean, your lordship, otherwise on record that is admitted position. My lord, what I am on, in fact, when censure imposed, my lord, it has to be treated as the period of suspension as on duty.
Where is that law?
Below,
Rather, there is a contrary law of the Supreme Court that if you are not blameworthy, then it is up to the authorities.
only I have not come across, because one circular central government is there.
That will not be
that
applicable.
under- Yes. But what I am on here, because I try to develop my case on the basis of
FRSR, Khansa. FRSR.
FR 54 million. FR 54B,
B.
capital B.
You want to develop?
Oh,
Mr. Goswami is also not there. When?
any day, without.
When?
So next
Tomorrow?
week, Lordship.
Tomorrow?
Lordship, actually, as per information, his uncle was expired.
Okay, that you should tell me first. If you had told me that he is in bereavement, I would not have proceeded. Okay, we'll have it on 20th.
Any day, because I'll do.
Mr. It's submitted on behalf of Mr. J.K. Goswami, Learned Counsel appearing for the respondent bank, that he is in bereavement. And accordingly, the matter be listed next week. Full stop. Mr. Kotogi does not object to the said prayer for adjournment. Full stop. List this matter again on 26/206 for further hearing.
Fine.
Just take me out of that. Only that. Otherwise, that decision being there, they have complied with the requirement. And censure, what I'm just clearing my mind, censure implication would be that you are not blameworthy. There is something, but they have said, okay, this is the penalty. It's a penalty. It's a penalty.
Comes under within the
Penalty.
penalty.
Obliged, Lordship.
Item 13.
May I please? My lord, I'm extremely sorry, my lord, I need some accommodation. Because, my lord, I have to reconstruct my chamber's file, my lord. It has been, my lord, misplaced. Lord, reconstruct my chamber's file.
What is the ground given for rejection of your case?
Since,
The
my lord,
co-petitioner was appointed. Got it somewhere. Wait.
my lord, can it be taken up tomorrow, my lord? I will.
No. Have your time. Mr. Mondal, M.U. Mondal, Learned Counsel for the petitioner, submits that his brief has been misplaced and accordingly prays for an accommodation today. Full stop. Prayer accepted. List this matter again on 24/6/2024 for further consideration.
You take up a tour.
No. Why two?
Lordship,
Why at two?
But here we are here like we is like code number 20.
Yes, Mr. Soga, what do you say? You were not here on the last occasion. That's why we placed it today. Okay, at 2. 2 o'clock. 2 o'clock.
Yes.
Dr. Minor, I made a submission that petitioner expired on day before yesterday. But since the respondent insisted, then matter was placed today. Need to substitute the legal error. For non-payment of pensionary benefit, this is the question. Yes, yes.
List this matter before
But-
any other bench without me.
Malad,
List this matter before any other bench without me.
on yes, I will also go to mention that.
He was an advocate thereafter.
Hello?
He was an
Yeah, he was-
advocate
he-
then. He expired.
He expired.
When?
But April, I think, April 24th.
Try before
So
some.
in the month of March 2023, he expired.
Ah.
And already family pension has been given to the family.
What more is left?
Family pension has been.
I'll not do it. I appeared.
Hold on,
My allot appeared.
Hmm. Hmm. Are you better?
Malad.
Are you better?
Yeah, Malad.
But you look very weak.
Very bad.
Where is the person who propped you up here? He's not, he's there. He's there. The younger one is here. Yes. What is your case?
My simple case is that, Malad, my juniors are drawing higher pay than me. This is my-
You were junior to XYZ in the feeder cadre.
Predicate.
Thereafter, by applying the graduation or the degree, BTech degree, you get a promotion. Now, XYZ in the feeder cadre were there even before you joined the service.
Correct.
So they are proceeding in that scale. You got promotion. Subsequently, they come up.
Subsequently,
FR 22A1 also applied in their case. Because of the fact that they have gone up much ahead in that running scale, they got a higher pay.
exactly.
How can that equation be made with you?
Yes, my case is that the principle of stepping up of pay should have been
Where?
applied to me.
How?
Malad, I'm
There is decision of the Supreme Court.
facts are clear, Malad, but Lordship may,
Nothing more than these facts. These
Nothing-
are the facts.
no, this fact one. Now, Lordship may kindly come to running page 43, just for clarification of the fact.
Hmm. Hmm.
43 is their document, Malad, where it clearly shows the picture, Malad.
No dispute on that.
No dispute.
You were not senior to them in the feeder cadre.
Exactly no.
Show me the law.
Because of the fact that they were in subordinate cadre, their requirement for promotion was 8 years of service.
So
In
they,
the meantime,
and you are relying on a government of Assam notification.
they are relying, Malad.
Or
They
whoever
use
is
my,
relying.
my,
And that is page 57, clause 2(3), Roman 3.
yes, Malad.
When a junior government servant promoted to higher post prior to his senior, as per special rules, special orders, he cannot claim equalization with his juniors, who is in fact senior to him in the base post. This is the law.
Which page 57, Malad?
57,
Which one, Malad?
down last paragraph, clause
When?
3.
When?
When?
Yes, Madam. When a junior government servant promoted to a higher post prior to his senior, as per special rule, special order.
Yours, this is a special provision in the rules that if you have a degree, you get a jump.
No, Madam.
Mr. Chakraborty, in your rules, that 11 maybe, 11 or 12, section 11 or 12, that if you have, after joining the services, acquired the
It is not-
BTech or BD, you will be given promotion against a direct recruitment post,
Exactly.
but you will be treated as a promotee.
Yes.
So that's a special rule. That's a special rule. That's a special provision.
And this is PWD rule, this is being followed by the department.
Everybody has that. So that is a special rule. So you are covered by,
Matlab, this is the service rule, and under the service rule, I am claiming the benefit. Now, this service rule is not a special rule. Special rule, my lord may kindly see. In
will
fact,
not go by that. It's only an indication. That special rule that they have said there, it's only an indication. But see, you were not junior to them, you were not senior to them in the FIDA cadre. So they have got a extended period. Now, by virtue of their service in the subordinate cadre, they having got a higher pay. How can you claim? Your seniority will not be disturbed. Although they get a higher pay, they'll not be senior to you. They'll be junior to you. But how can you claim this?
I don't have any conflict with them.
1996, 7 SCC 211.
I have relied 3 judgments. The principle of stepping up has been discussed, my lord. That should be.
One is Calcutta.
One is Calcutta.
Calcutta will not be applicable. Second one is.
But it clearly says this is a settled proposition of law that a senior cannot get pay lesser than the junior, my lord.
That circumstances have to be seen.
Here the circumstance is same, my lord.
No.
Can you see in this case, first case, my lord.
I found the judgment somewhere here.
P. Jagdish, my lord, Union of India, P. Jagdish,
Uh-huh.
97, 3 SCC, my lord.
Just a moment, just a moment. I found that judgment. Wait. Okay. You want me to go to 1990?
1997, 3 SCC, 176.
1990,
The judgments copy are given last occasion, my lord.
1997,
3 SCC,
PSCC.
176.
Can't I be a little bit tech savvy? Or should I remain like that for all times to come? Huh?
My lord.
Can't I be a little bit tech savvy?
Sure.
Yes, read.
Here.
That is that Calcutta, that is not Calcutta matter.
Calcutta matter. This is, my lord, some other. Union of India, please, my lord. Paragraph 5 onward, may I read the facts will be there, madam.
Slowly.
The question for consideration therefore would be whether the respondent who had not been posted against the identified post carrying a special pay of 35 per month can even claim fixation of their pay with 35 per month in the cadre of senior clerks, even on national basis. Here the claim was that respondent said that the 35 rupees which was given to others should also be given to them, madam. So Supreme Court has said that they are not entitled for that.
That's not applicable here. There is nothing.
That is not applicable, madam. Whether the respondent can claim for stepping up of their pay in the promotional cadre of head clerk when they are juniors who were later promoted.
And see the words. When they're juniors, not their seniors.
Madam.
The ratio here is juniors.
No. Ultimately, due to getting that special pay, 35 rupees.
You come to that second part. Whether the respondents can claim for stepping up of pay in the promoted so and so. When the juniors who later promoted were fixed at a higher slab in the so and so, taking into account the special pay which they were drawing in the category of senior clerks. Here, 35 plus juniors.
Junior.
Okay,
so,
proceed.
So with this 35, they went up in the next cadre. Due to that 35 rupees and other reasons, my lord, they were getting, the juniors are getting higher pay than the seniors, my lord. Now, this has been answered, my lord. 6, it has been, I'm skipping, my lord. 6, 35 is not applicable. You cannot claim 35 because that was a special. 7, my lord. So for the second question is concerned, it depends upon the applicability of the principle. Admittedly, the respondent had been promoted earlier to the category of head clerks, and some of their juniors who were continuing as senior clerks against the identified post carrying special pay of 35 per month on being promoted to the post of head clerk later than the respondent got their pay fixed at a higher level than the respondents. under the provisions of fundamental rules to remove the anomaly of a government servant promoted or applied to a higher post, either drawing a lower rate of pay in that post than another government servant junior to him in the lower grade, promoted and appointed.
And then
subsequently.
another government servant junior to him in the lower cadre. Now proceed. And promoted or appointed subsequently to the higher post. The principle of stepping up of pay is applied.
No.
In your case, it is the reverse. In your case, the junior was promoted earlier by way of an special provision. Subsequently, the seniors come in. Here, the seniors have not been given any benefit. Only they are continuing to the larger extent in that running scale of the feeder cadre. So when 22(1)(a) was applied, so they came to be placed at a higher stage. Now, how can you claim?
My only claim is that I am not in conflict with my junior. That seniority and
Nothing.
Only thing is that in the cadre of assistant engineer and all matter, assistant engineer, assistant executive engineer, and executive engineer, I continue to be senior with them.
You will be.
Correct. That's the facts I know, madam. This is because of the fact that that they were appointed.
No,
I was
they were appointed in the feeder cadre earlier, and they continued in the feeder cadre for a further period of time after you were promoted by applying that special provision. They had a length of service in the feeder cadre, so they drew more increments than you. After you were promoted to the higher cadre, they again drew further increments in the lower cadre. So when their case was fixed for promotion to the higher cadre, naturally they came to be placed at a stage above you. How can that be an anomaly?
That's right. That facts are not in this. Only thing is that only law which is to be discussed here, madam, I being senior in a particular cadre, assistant engineer, assistant executive engineer, whether I have a right that my pay should be stepped up to the level of the junior.
For the asking, you don't get it.
No, but there is a law being, I'm reading paragraph 7, Lordship.
This paragraph 7 is in a situation where a senior was promoted, thereafter the junior was promoted. Then the Supreme Court said, okay, fine, consider.
Supreme Court has said that the fact that, in view of the fact that they were getting a special allowance, they're getting higher pay. Supreme Court.
You read that, Placitum F, just few lines above.
F.
Under, Placitum F above, under the provisions. Just below E, Placitum E.
Under the provisions of fundamental rules.
To remove the anomaly
of a government servant promoted or appointed to a higher post, earlier drawing a lower rate of pay in that post, then another government servant junior to him
in the lower grade,
yes,
and promoted
and appointed subsequently to the higher post. The principle of stepping up of the pay is applied.
That's it. That's the law. Now read.
May I read that one paragraph, madam, I'm reading with.
In such cases,
In such cases, the pay of the senior officers in the higher post is required to be stepped up to a figure equal to the pay fixed for the junior officer in the higher post. The stepping up of the is required to be done with effect from the date of promotion or appointment of the junior officer. On refixation of the pay of the senior officer by applying the principle of stepping up, the next increment of the said officer would be drawn on completion of the requisite qualifying service with effect from the date of refixation of pay. This principle become applicable when the junior officer and senior officer belong to the same category and the post from which they have been promoted, and in the promoted cadre, the junior officer on being promoted later than the senior officer gets higher pay. This being the principle of stepping up contained in the fundamental rules, and admittedly the respondent being the senior to several other senior clerks, and the respondents having been promoted earlier than many of his juniors who were promoted later to the post of head clerk, in principle of stepping up should be made applicable to the respondent with effect from the date their juniors in the erstwhile cadre of senior clerk were promoted to the cadre of head clerk, and their pay was refixed in a higher slab than that of the respondent. The stepping up should be done in such a way that the anomaly of junior getting higher salary than the senior in the promoted category of higher clerk would be removed, and the pay of the seniors, like the respondents, would be stepped up in a figure equal to the pay X fixed for the junior officer in the higher post of head clerk. In fact, the tribunal by impugned order had directed to apply the principle of stepping up, and we see no infirmity with the same direction subject to the aforesaid clarification. This principle of stepping up, which we have upheld, would prevent violation of equal pay for equal work, but grant of consequential benefit of different salary would not be correct for the reason that the respondents had not worked for the post to which
This is
35% special pay was given.
This is different.
This is different.
This is
has not been
different.
allowed.
Principle. The earlier part, the underlying thing or the factor is senior promoted earlier, junior coming later,
Yeah.
and the junior drawing a higher pay. No, give him parity. But in your case, it's the reverse. Junior going up.
Really, is a different thing, but if you lost.
You check up this decision. 1996, 7 SCC 11.
1976,
1996,
96, 7,
7 SCC 11.
page 11.
Hmm.
Much. So I'll go through that. And the second one, Mala,
Hmm.
only para 17.
Gurucharan Singh, Garwal.
No, Mala, it's yes, ma'am. It says there is a settled principle of law that a senior cannot be paid lesser salary than the junior. That's why the principle of stepping up, my lord.
No, but here the stepping up would be also, you will have to see why. A person with such a long length of service, how can he help to be
Yeah.
not?
Here it is long length of service. There in the earlier case, my lord, granting a special allowance.
No, granting a special allowance of 35 to certain posts, not all.
Their post, my lord. Those
That
posts.
Supreme Court said nothing doing.
My lord.
You are not going to get it. But while going to say that, it had laid down the law. That this is the thing. Senior gets promoted. Subsequently, the junior comes up. But the junior is getting a higher pay for whatever reason. Make it. But when a junior under special circumstances is promoted, how can the senior be?
I have two submissions in this regard, my lord. The promotion which was given to me is not a special law. It is the it has been followed.
It's not a special law in that sense. It's a special provision.
But my submission would be, Lakshmi kindly read that, my lord, in my submission, my lord. Lakshmi kindly see that is even for a different context. That refers to a reservation law, my lord. Lakshmi kindly read it, my lord.
Which one? 11.
That no,
11, Mr.
No. They are circular, my lord. 57. That is saying that he is a little bit not controversial. I mean, read it, my lord. 3 refers to special Romans like reservation law, my lord. As you can see, my lord, when a junior government servant promoted to a higher post prior to his senior, as per special rule, he is confusing. He cannot claim. He means, my lord, it refers to the senior man. He cannot claim equalization with the junior, who is in fact senior to him in the base post. If this is settled provision, my lord, it refers to reservation law, my lord. He is little bit confusing. He is not the junior man, he is a senior man. So that has been clarified.
How can you say
My lord.
that this is with regard to reservation?
But it says, my lord, in
Where?
reservation case, we know, my lord, the junior supersedes the senior.
No,
Then
no.
the senior cannot say-
Where? Finance department receive a number of proposal for
Yes, ma'am.
equalization. So and so. On examination, so and so. Servers are without examining. Equalization or so and so. It is therefore in present. Proposal carefully. This is general. It does not only envisage a that is
So
one
it says
circumstance.
that the cases are being wrongly cited.
That
Cases
is
are being-
one circumstance. Maybe one of the issue.
But this C is not applicable in my case, madam. This is regarding when a special rule, someone is giving accelerated promotion, then senior cannot say why. my junior
Reservation
can-
law is not a special rule.
My lord.
reservation law is not a special rule. Again, it's a normal rule. It's a normal rule. Then,
That is the constitutional provision.
so we'll have to understand this, that you got that promotion legally.
Then the special goes, lordship is, what lordship is coming under, since I was junior.
Junior, you
So
read
my,
that,
I'll go through the judgment, my lord, lordship, give me
Two.
some time.
2 o'clock. Just go through it.
Some
2
other day,
minutes.
madam.
2
Some other
minutes
day.
it'll take. Just get him that judgment.
At 2.
Yes, Mr. Borpujari, what do you have to say?
He will be relying on the affidavit because here, my lord, admitted position is that he was promoted out of turn.
Don't use the word out of turn. That is his right.
No, that is.
That is his right. But show me why the junior who comes up, senior who comes up subsequently.
No, because I will be relying on the office memorandum.
You
issued by
justify that office memorandum for me.
No, because my lord, subclause 3 says, my lord, when a junior government servant promoted to a
So
higher post.
show me decisions of the apex court in support of that. That contention. 2 o'clock. Work. That is what is required. So that we can
No, no, absolutely.
satisfy Mr. Chakraborty that we have done the right thing.
Madam,
Right?
I'm taking,
Second up.
I'm obliged.
2000. আর কিবা আছে নেকি? মোশন এই তো লিস্ট শেষ নেকি? টপ অফ দি লিস্ট শেষ হ'ল। মোশনটো মাতা। Yes, Mr. Fugan. Ms. Fugan, what do you have?
DO has wrote a letter to the block elementary education officer to take SMC number.
That number 3 or number 5?
Number 3 and number.
Let this block elementary education officer come here. He's not doing anything.
2 p.m.
He'll come from Mulberry
Yes.
He already prepared all the
because the
documents.
DEO is saying that he is issuing letter after letters. He's not doing anything. So if that be so, we will discuss with him what is the problem.
Madam will be taken at 2
Okay.
2 p.m.
You get your
Madam,
instructions from.
tomorrow.
No, today. You get your instructions.
Madam.
See, madam, it's easy to say tomorrow. If I say tomorrow, this file again will go. There will be another 10 people required to handle that file. Why? We'll finish it up today. 2:30, no problem.
Madam.
You come back, tell me when you have that instruction. Before my rising, you tell me. And I want it from that, why this letters from a superior is required.
Yes.
And there is an court order. Why is he not acting? Is he in? Huh? I'm not using that word with Mr. Dhar. Maybe. Check out.
Deeply up.
The last occasion, this honorable court held that
instead of taking up the stay vacation application, the main repetition may be taken up. In that time, the government is.
Who are you appearing for?
I am for the petitioner. my lord.
And Mr. Deka,
I'm for the respondent, Lordship.
respondent who?
Respondent number, Lordship,
6.
sorry. Yes.
Hatem Ali Khan.
Hatem Ali Khan.
Okay, we'll consider it. Today itself. 2 o'clock.
After some time.
Huh?
2:30, my lord. Not.
No problem. No problem. But anyway, 2 o'clock, I have fixed some other matters also. Come back.
But they have to produce the record, my lord.
That if they produce, otherwise you establish your case. You don't have a matter, case. You don't have a case on merits.
I have a case, my lord.
Then why are you going for all this unnecessary?
But there are
things?
2 recommendations made by the district court.
Got it. You show that to me. Duta bajat mati go. Hoba, duta bajat mati dio. Come back at 2.
Admission item 18.
Duta bajat. Duta bajat mato. Regular. Duta bajat mato. Yak mati dio. Mr. Barmia, we'll have it at 2. Just right. Come back at 2 and we'll have it.
Yes.
You have some problem? Boy,
Some time is required in this petition.
that's it. We'll have it on some other day. Today may not be possible because I fixed up a few matters. So there is a parted matter also. When do you want it? Thursday. On the prayer of the parties, list this matter again on Thursday. Thursday. Mistake. We'll try on that. Yes, Mr. Aruto.
Item 22.
Ah.
22, there are 2 analogous matter, Lordship. 22, 22. Can it be after 1 week, Lordship? My understanding is also appearing.
What was the issue here?
I'll file affidavit in opposition.
What is the issue?
Lordship, principal of a HTTG college was put under challenge. Appointment of principal.
It'll take some time. We'll have to finally hear it.
Lordship,
You're not filing a rejoinder?
no, Lordship. I'll file
No.
affidavit.
You have filed.
No.
You will file.
No, I'll file.
On the prayer of Mr. P.P. Dr. Lanik Council, appearing for the respond number 5, item number 22, Klipibo. List this matter again. When?
Vacation, Lordship. That may be fixed, my lord.
After vacation? Or before vacation?
Before vacation.
List this matter again on 27th. The respondents are at liberty to bring on record their stand by way of filing an affidavit, if so advised, before the next date of list.
Item 24.
22, 23, 23 to list along with so and so currently.
Item 24.
Huh?
Item 24.
What is there?
After 18th of June,
Why?
if is a parted matter, I heard my lord, some parted matter.
Parted by somebody else. Then
No.
we'll come back, we'll see what can be done.
Justice K. Ramaswamy.
Hmm.
It was delivered on November 20th, 1995. The judgments I am relying, my lord, 3 judgments. Out of that, 2 judgments are the same bench, K. Ramaswamy. The earlier judge, the subsequent decision, it says it is.
There is a slight change in the facts in this other 2 cases, Calcutta and the other one.
But I am relying on this particular line, my lord. This is a settled proposition of law. That the
But this judgment which I gave you
My lord.
is on the point.
My lord.
That's on the point.
Yes, my lord. That says it, but the judgment I am relying, my lord.
I got it.
Let me consider, even the Calcutta judgment, there are ratio,
See, Calcutta judgment, there is a line that the factor is just opposite what is there in your case. Therein the senior was promoted, then the juniors followed. But in the judgment, other one of Justice K. Ramaswamy, 1996, 7 SCC, it follows a judgment of 1989.
Yes, earlier judgment.
Earlier judgment.
Earlier judgment.
But that was not considered. I don't know why. It was not considered in the
No,
subsequent
just
judgment.
after 1 year later, the same judge has
So-
passed a judgment that I have relied, my lord. That says, my lord, possibly the judge became wiser in the subsequently, my lord. deposit
But
judgment.
given the facts involved, I think I'll have to follow the earlier one.
My lord. But, my lord, lordship, facts are there, my lord. My only thing is that the judgment I'm relying everywhere, the ratio, one ratio has been laid down that the senior cannot get lesser pay than the junior.
To counter
That-
that,
that
I
is-
can only say one thing. A judgment is the facts.
Fact. But the language that has been put, my lord, it is a settled proposition of law that a senior cannot get lesser pay than.
But that has to be understood in the context.
In the context. But see, Calcutta judgment, lordship, take for a moment, my lord. That is
Calcutta.
also Calcutta judgment that I have given copy, hard copy, my lord. Paragraph 6, lordship, may kindly see, my lord. That is also by Justice Summation, my lord. Last 3-4 line and then.
Para?
Para 6, my lord.
Under those circumstances.
My lord. A reading thereof clearly indicate that the principle of stepping off
I
of
marked
the
it.
pay would arise only when the junior employee on his promotion is drawing higher pay than his senior. In that case, they would be entitled to the stepping up of the pay so as to be at par with him on the principle that a person who are similarly situated and drawing the same scale of pay and are doing the same duty and being senior to the person drawing higher pay are entitled to have their pay stepped up. But the principle is inapplicable to the situation as in the present case, where a junior person on transfer to a different place being an extra payment, so and so, that is. The last 4-5 lines, my lord, under those circumstances, we think
That the
statutory
statutory principle of setting up, I marked it.
when
Not
all
be
of
on a
them
rational
discharge the same
principle.
duties under the same responsibilities and not in different circumstances, if the juniors draw higher pay than promotion, the seniors who do not get the opportunity would be entitled to parity of payment. So that's it, my lord.
Can you give me a copy of that 96? You have an extra copy.
96, yeah,
Oh.
I have.
You have retired.
I have retired long back, my lord, 2004.
During the pendency of these proceedings? Or before
No,
this?
earlier I came before this honorable court.
Thereafter you retired.
There also a judgment was there, this direction that my paper be considered. That was not done. Only a legal proposition of law, my lord, if I am there, otherwise.
Para 6 of this judgment, 96, that 89 judgment was,
89 judgment followed, madam.
but I don't know
I
why.
could not see that judgment, my lord.
Same proposition,
Same.
something in the similar sense.
But my submission, my
Another
lord,
candidate was drawing higher scale of pay due to length of service in the feeder cadre. It would be grant of special pay for the purpose. That would not be a grant of parity of pay scale to the seniors working in the cadre.
clear, madam. That is very clear. But
So I was having some problem with this proposition. I was going through certain judgments. Then I remembered somewhere. You know my habit, I forget.
Right.
So yesterday when I was going through my book, I got this. We'll see.
that is creating a problem for me, madam.
No. It's a legal principle.
All right.
We'll see. Heard Mr. B. Chakraborty, Learned Counsel. Anything more? Any judgment?
Calcutta decision which he is relying, my lord, is squarely opposite. They are, my lord, the persons, my lord, the junior employee on his promotion was drawing a higher pay. Because that cannot be
Anything
applied.
else? Anything else? Anything more you want to submit?
My lord, I have also gone through which decision lordship has, my lord, spelled it out. 1996, that Andhra Pradesh decision. 1989 earlier decision was relied upon, my lord.
But I don't know why the same judge in the subsequent judgments did not. So only thing we can do is, we can draw a presumption is, to satisfy Mr. B. Chakraborty that the other cases had a different factual matrix.
Therefore, my lord, what he has done a lot of work, I appreciate. But on facts, my lord, with all
He has not
humility,
done any work. Do you think he has done work? This is normal for him. This comes normally to him. You don't know that. Mr. Chakraborty, they have not understood you. These, you mean to say these judgments he has searched out? It's normal. It all normally comes.
So, my lord, on facts, my lord, maybe, my lord, he is trying to draw up a conclusion.
But see, this law is still not very crystallized. There are judgments of this court also you will find
Yes,
both ways.
yes, both ways.
Both ways.
Because
But honestly speaking, Lord, that judgment I didn't get it. That Lordship has pointed out.
Huh.
I didn't get it. No, honestly speaking,
at, my lord, my respectful submission would be, my lord, here, my lord, the fundamental rule 22 may come to rescue.
Earlier, there was a problem with because there was 22C in
Not
operation.
with- yes, that's then we have
Once
taken
that has been
deleted.
deleted,
Yes,
then the situation got changed.
yes.
22C is not applicable in my case.
It won't be applicable.
No.
No, I'm saying because of the judgments, if you say earlier judgments were on that 22C.
Applicable because 22 is deleted in 1989, and my day, my.
No, I'm not on that, Mr. Chakraborty. That 22C, that flavor was there in the earlier judgments. It was on that 22C.
Yes, because
Anyway, heard
statutory.
Mr. B. Chakraborty, learned counsel for the petitioner. Also heard Mr. R. Porpujari, learned counsel appearing for
The finance department.
the standing counsel finance department, and Ms. M.D. Bora, learned counsel appearing for 1 and 2 transport department. So hearing concluded, list the matter again on 19th for delivery of orders. In possible, I will this also. Let me also examine once more.
Upon going through that decision, my lord, which lordship has drawn attention to 1996.
There is an umpire waiting and seeing everything. You both are arguing, but an umpire is enjoying.
One aspect of the matter, my lord, I am enlightened. My lord, Article 39A, that argument is drawn up, built up. How?
Gone. That is also now gone. Now you'll have to answer to the master what it is.
I'm so obliged.
Yes, is it? Oh. 52. Just finish up with this. Where is Mr. Kale? He was here today morning. Yes, madam. Where is Mr. Kale? Oh. Have you given that note which I wanted?
Should I inform him, Lordship?
He's in court.
He's in legs, Lordship.
This judgment 2004-11 was not there in the compilation, I suppose. Or was it there? Madam Gope, was it there in the compilation? 2011? It was there.
We have given Manupatra.
Hmm?
We have given the, even the.
Manupatra here. That's it. Yes, Mr. Cal.
Maybe prepared and not.
Yes, what do you say on that point?
Lordship, with regard to that, I have obtained instruction.
Hmm.
Lordship, pleased to see that earlier also 4 summons were issued.
No, we are on the summon of 31.
Yes, that was for further inquiry also.
Hmm.
That was
Same 108. Earlier summons also
Yes, but-
108.
but they submitted some documents earlier that on inquiry, preliminary
No,
inquiry. It was
if I may put it in perspective.
Also, pleased to note the dates.
26 is the
2017.
Ah.
Thereafter, summons were issued to
on 27.
Sunanda Bhumik Lordship, from whom were initially recovered.
Hmm.
He produced some documents issued by the Manikchand Jewelers.
So you wanted a confirmation of
The
that.
confirmation that.
So that is the document, 27-8, page
these are the
31.
documents. On that basis, Lordship,
This is the first one,
yes, Lordship.
first 108, right?
Hmm.
Then comes the letter. Then comes the second one,
Yes, Lordship.
right?
Every time
31-8.
27/8, let's see, page 24 of my affidavit. First, page 23 of my affidavit. Lordship.
Just a So they gave a thing that 3-4 days time they want.
Yes,
Then you issued this 27-8.
against 27, someone was issued.
So 24 is earlier, then comes 23.
23, they said that,
Subsequently,
your summon dated 27/8/20.
that summon is at page 24.
Now that is to Krishna, so yes, Lord.
Yeah,
That is-
right?
Then that is to the farm.
Where is this 20? The summon dated 27-8-2017 in 23. I think that is 24. Krishna Kumar Soni.
On 26, Lordship, goods were recovered.
26th detected.
Yes,
27th first notice.
first summon.
28 reply
28
seeking
reply
time. The notice was to one Mr. Krishna Kumar Soni.
is out of station.
No. So just confirm 24 precedes 23, right?
24 is, Lordship, it was issued to Sri Krishna Kumar Soni.
That is the reply at page 23.
Now 23 is by Lordship, no. Lordship,
No. Issued someone to
Your summon
Krishna
dated-
Kumar Soni.
Krishna Kumar Soni to appear.
Why do you have summoned dated so and so? You have summoned Krishna Kumar Soni to appear. And that summon is at page 24.
Yes, Lordship, correct. Yes.
Somewhere it was just, this was received,
It was, place of,
what be that as it may. Then
Page 25.
28, there was a summon to Sunanda Bhumik also, 27. He produced certain documents. That is at page 26, right?
26, yes.
So these are the two summons issued, one to one of the authorities of the shop establishment and one to the carrier.
Yes.
Right?
Yes.
Then you come to page
Page 30.
34.
34, yes.
Hmm?
Is a summon dated 31/8/2017.
Right?
Lordship, please to copy page 30.
30.
Lordship, please to, before that, Lordship may come to page 26. Please, go through the, Lordship, I want to place the content of the summon.
Sunanda Bhumik.
Sunanda Bhumi. Whereas the detention of gold and diamond ornaments have been done under Custom Act 1962 and the same is being inquired under my order. And whereas I have reason to believe that you are in possession of facts and documents and records which are materials to above inquiry. You are hereby summoned under section 108 to appear before me in person.
Custom
on
Secretary.
28
Custom
2017
Secretary.
at
Okay.
Custom Office so and so to give evidence truthfully and such matters so and so. If you fails to comply, then schedule any document in support of detention of gold and so.
Mr. Cal, just for my satisfaction, as far as 27, as on 27/8/2017, the reason to believe that the material would be required to confiscated has not been arrived at. You are still in the inquiry stage.
Yes.
You are just looking into it. This also nothing happened. Some documents were given, thereafter nothing happened.
Yes, sir.
Then the next one is
Page 30.
34.
34 is the summon to
Manik Chand Soni.
Yes.
Now, earlier somebody else, now you come here. Second paragraph. Whereas I have reason to believe that you are in possession of facts and or documents and records which are material to the above inquiry.
Yes.
So this is to arrive at the conclusion that no, these materials are smuggled through a route not otherwise
Yes.
done. So till 31/8/2017, when you were issued this letter, you had not formed that opinion, reason to believe. Right? Now, next page, 35. Without forming that opinion, what material was with you to come to this conclusion? No, this has to be seized because now it will be confiscated.
No, Lordship, it is correct. Lordship is correct, but Lordship may come to clause 3, place and date of seizure.
No, that is seizure is
10(5), reason for seizure.
initially detected on
Reason-
26.
Yes,
5.
it's a chronological event.
So and so, so and so. But this one, that 5, you are not having materials. You have
No,
set
no.
on 1.
Lordship, I placed the order sheet. I'm again reading for myself, Lordship. It was learned that Sunanda Bhumik was admitted in hospital through lawyer. The lawyer also, Sri Krishna Kumar Soni, was out of session. As such, the investigation verification process come to a halt. Then on 31/8/2017, a summon was issued to Sri Manikchanda Soni, who signed the delivery challan to appear before the Superintendent Custom on 1/9/2017. Thereafter, from the development in the instant case, it is observed that even after the 4 days, already Lordship was 26, 27, 28, 29, 30.
No, then why did you issue this 31?
Lordship, the explanation
That is, you are jumping the gun. You committed yourself on 31/8 to get the documents on 1.
No, Lordship has seen the earlier.
If you
summons.
had done this on 1 first, we would have agreed.
That time, Lordship,
If not, why?
that is the explanation.
And what I have found is, this is very technical. If you don't do it in the manner required, that is gone.
But here, Lordship, the case is, it's a very peculiar case here. Here,
Be that as it, I am not on anything else. I am only on
no, Lordship has to
the
see.
materials.
No, before come to a conclusion, Lordship has to see if the previous conduct and previous events also Lordship taken into consideration.
See, that was waived by you. If you had the first notice, 27th, that he is not there, enough.
No,
You should have proceeded. We would have been with you. But you say that I want to have that. I believe that you have those documents. Show me. So still tentative. And in that note, you will find
Yes.
that 31st, maybe morning this was issued. Then he goes and writes that note. How can that be possible? If he had written that note on first, I would have understood. Because first also they did not appear. The lawyer went.
No, that is there. If there is a note on 1st of September, it says that in the instant case, a letter is prepared and sent for Sri Sunanda Bhumika.
That is the reasons which is there in that note.
Intimating the reasonable belief for seizure. And Lordship has to consider the reason to believe also, what we have stated there. I am again placing.
That is what is creating problem for me with this letter at page 34. When you made that, you could not have come because Mr. Cal,
Lordship,
if you come to that seizure,
yes, page 35.
4 gold bankles, 4 gold bankles. Just see the note on the right hand side. Covered by delivery challan number so-and-so dated 26/8/2017.
Which page, Lordship?
Page 35.
35, yes.
That seizure report.
Reason for seizure.
Reason for seizure, remarks. Details of goods is 6.
6, yes.
So this item number 1 and 2 covered by a particular delivery challan.
Yes, Lordship.
3
no
submitted,
document,
that also submitted on 28/8, delivery challan. Last line.
no document found at the time of
Detection, delivery challan number so-and-so, submitted on so-and-so.
26/8/2017.
So then mixed diamond, covered by delivery challan.
Delivery challan number 20.
1 civil silver pile, no covering document. That cannot be construed to be such a major thing. But item number 1 to 5 were covered by documents. That is why you wanted a verification of that in page 34.
Yes, correct.
Now, have you come to a conclusion that these delivery challans are all forged?
Then Lordship have to see the letter dated 1/9/2017.
We'll not go to 1/9. We are in 31/8 when you seize that material.
No, Lordship.
Even in that letter of 1/9, you have not said.
Married, Lordship.
Yes, I'm coming to that. I understand what you're trying to do. Moreover, delivery challan number so-and-so submitted by so-and-so appears to be a manufactured after point, pointing towards malafide intention, thus necessitating a detailed investigation. Now, this material, this conclusion, you could not have arrived at without that documents either being produced or the time for that expiring.
No, that was already produced by them in earlier occasion.
No, that is why you were asking for the originals.
No, Lordship. Coupled with the events which was already passed.
Then what was the necessity of issuing this page 34 summons?
Yes, that Lordship, but in my
What made you immediately take a vote?
No, Lordship, then subsequently also summons were issued. Subsequently also summons were issued.
We are not concerned.
No,
This matter attained finality as far as the seizure is concerned on 31/8. We are there. If this is opened, then the rest of the proceedings will follow as per law. But here, the challans were there. At least 1 to 5, 6 is immaterial.
That's reason he has been given.
That reasoning you could not have. Because you did not have the material. This reasoning would have been valid if you had given it on first?
No, Lordship is to consider, they've submitted some documents earlier also.
You have not, you were wanting to verify those.
No.
Mr. I can understand the situation. I got certain documents. I'm not convinced.
Correct.
So Mr. Kal is the original, the owner or the possessor or the holder of those documents. I asked Mr. Kal, I'm fixing this matter on first. Kindly get those documents to me so that I can come to a conclusion. On first, I again take up this matter. Mr. Kal, where is the documents? Kal's junior comes and says he's out of station. Then I draw a presumption. See, Mr. Kal is deliberately not producing these documents. These are afterthoughts. So this materials, reasonable doubt arises. So I am seizing it because this may have to be confiscated. Understand? But before that date,
31 summary.
you don't have an astrological help, I sure,
No,
in
definitely.
the customs department.
Definitely.
So
That is, Lordship explanation is that what happened, I received information from the person who was conducting the search. He said that document was there and
if the document was there, he is not an officer fit to be there. He should not have issued this 31A.
That is Lordship.
This shows that he was not, his views had not crystallized.
No, that,
Tentatively also.
but issuing of summon 38, probably they could have waited for another 1 day.
Simple. They don't come. If they come also, they come with a plea that he's not there. Enough. You can draw that conclusion. That's it.
But that should
We
have
had
been
given you.
That should have been on first.
That should have been on first after the time for them to appear was over.
Because on third, they submitted application that they are not in.
No, they submitted an application on first itself.
No.
First itself. You come to page 32.
Lordship, page 30.
No. Or 30, yes.
No, regarding Sunanda Bhumi, it was submitted on.
Forget Sunanda Bhumik. We are on the summon to Mr.
They submitted on 1, page 32.
32.
You are like.
So-and-so 82-year-old man with so-and-so,
With
it's
a-
not possible.
for the
So you are asked to
of
consider
special
matter.
treatment.
Now, if you had proceeded, say you are dilly-dallying,
That is all.
finished, otherwise gone.
But my explanation is this.
That's no explanation.
And subsequent also summons were issued. They didn't.
We are not concerned with the subsequent summons because the incident happened and finished on 31/8 itself. I will even go with you that the note of 31/8 was there,
What is
communicated on first. My initial view, which was there. So that I would have been with you. But
130 that
31, when you say that, wait, and see, I have reason to believe that you are in possession of facts and records which are material to the above inquiry.
that is their.
That means what? The documents, whatever was with you, you were not in a position to take a view either way. Now, in the evening, I'll hold the word evening. You come to a conclusion, no, these are all afterthoughts. Can't help it.
He could have passed order on.
He could have waited. What was the rush for him? Or is there any target that on 31st he has to do this much, seize so much property or something? These targets are there. So maybe.
Regarding Lordship, notification is not with me. Probably that will go against the department. After seizure, they cannot hold the goods with them. That a rule is also there.
That has to go to where?
No, they have to seize immediately. They cannot.
26th.
Yes, sir.
That's what I'm saying. 26th in this case, that's the difference. That's the distinguishing factor. Because normally when you seize those gold diet articles, wherever I have appeared in 1 or 2 matters, you have got no materials, you have got no documents.
That is the.
So immediately you can come to a conclusion that this is smuggled. But here the problem was forged, afterthought, made, whatever it is.
No.
Documents were produced to you.
In this, what happened when the goods were recovered?
That was recovered by somebody else.
No, that was yes, by the RPA. Sorry, CISF.
CISF.
Then it was handed over to custom. on the inquiry, he could not produce any document. Subsequently, he produced some document.
No, that
Yeah.
again is wrong.
Yes, Lord.
Because here you see, wherever he had produced documents, page 35, you mentioned documents were there. Only one, that is serial number 3, he produced on 28/8/2017, but the document is dated 26/8/2017.
Lordship, if my affidavit, paragraph 3.
Paragraph 3.
Repeatedly.
Hmm.
Married.
Hmm.
That on 26/8/2017, the CISF LGBI airport informed that during pre-embarkation security check at around 19:20 hours, one gold bangle was concealed in upper arm of the passenger, namely Sri Sunanda Bhamik, son of so-and-so, President so-and-so, have been detected by on CISF officer, LGI airport one passenger. Further scanning, checking of his hand luggage, gold and diamond jewelry were detected by on duty CIS at X-ray baggage inspection system. On being asked, the passenger produced delivery challan number so and so in support of gold and diamond jewelry, but could not neither produce any document in support of gold bangle kada, which was concealed in his arm, nor could provide any satisfactory answer in this regard. Further, it was observed that some of the gold jewelry had diamond and precious stones like items embodied on it. Presence of transit challan for the jewelry and absence of any document for kada raises suspicion, and as such, a preliminary verification become imperative as to verify the authenticity of the recovered item documents and also call for other documents. The passenger claimed to have. Also, it was observed that the recovered delivery does not comply with the invoice rules under Central GST Act 2017, and thereby raising suspicion on the intention of the carrier procedure. Though the place of occurrence was far from international border, but there was no
You got it, Mr.
every possibility.
That got it. Now, one thing which I don't find here also, in your report somewhere, you have recorded a statement or something that these materials were being taken to Calcutta.
Yes, Lordship,
For-
the statements are here.
No, not the statements. In some document for repair. I found this somewhere. But while seizing the materials, you have not made any reference to the condition of those gold jewelry. You could have said that prima facie site, these materials don't require any repair. So we have that this is gold converted into jewelry and now being smuggled in this innovative method. That is your apprehension. Okay, we'll consider. Anything more, Ms. Gopi?
Lordship, in my written submission, I've quoted some judgments.
Hmm.
Lordship, I'm sorry, Lordship, I could not provide a copy.
Wait.
Tomorrow I can,
Permitted.
particularly the paragraphs.
Just a moment. Else have you to put good. Else have you to put good. Yes.
The last page.
Whatever is relevant, you can give me copies.
No, only the paragraphs is I'm relying, I'll supply tomorrow. Because there is a power breakdown in my.
No problem. Power is broken down everywhere these days. My place also. Okay. You can just leave it with him tomorrow.
Tomorrow. What is the
30.
paragraph?
Anything more?
only the customer statements, if lordship wants to see the
We're not
customer
going to-
statements are there by the
You're not going to go.
in affidavit and reply.
You're not going to go. Heard Ms. M. Gop, Learned Counsel for the petitioner, also heard Mr. S. C. Cal, Learned Standing Counsel, Customs, appearing for the respondents number 224. Four. Hearing concluded. List this matter again on (21/6/2024) for delivery of orders.
Much of.
You can just leave that with him. Your junior can leave it with him.
Tomorrow.
Muk didi ko. Yes. Dice code.
Dice that has for 9, 10, 11, 12, 13, 14 have given me.
Where did you get this? Where did you get this?
It was given to the petitioner school immediately after giving the dice that
Yes, Mr.
ABRCC has supplied the copies immediately by the company.
But he got nothing, no authenticity here. How can we?
19 data you can also peruse. 19 data, everything is printed.
9, 10, 11, 12, 10, 11?
10, 11, my lord, I did not get my lord.
12, 13?
12, 13 is also there, my lord.
But this should be there in their records also. Now that you are saying that
No,
these
they-
are there,
they say that
how
my-
can I take cognizance of this?
but they
This
say-
has to be proved.
They says that these data, that the datas of earlier years, my lord, they that do not have presently, my lord, with them.
Not presently. They say it's not there. Not there. Not presently. It's not there.
Then, my lord,
Your data starts from 14, 15, right?
Because there is a printout has given you.
14, 15.
possibly kindly consider one thing.
Annexure 1,
Next one, 107.
14, 15 onwards. See the corresponding statement. That from since 14, 15, so and so, you are there in Sonitpur district, and the same school is in Vishwanath from 21, 22. As per record, petitioner school bearing so and so is not found in the year 2009-10 as claimed by the petitioner. Categorical statement. And this coming from the authority who is required to maintain that.
That is
How
true.
can? You will have to establish this, Mr.
One thing to appreciate that the dice that a number is same against which my school was provincial.
We got it. Now that the dispute has arisen, the issue is that we don't have it from 9-10.
Yes.
They say it's not there. It's not that we can't retrieve it. It's not there. You started from 14-15. Now, this may be true. This may be authentic. There may be some problem somewhere. But for me to take note of this, I'll have to draw a conclusion that this is perfect.
File an additional
This is,
affidavit.
no need, filing an additional affidavit also not bring it on record, because I'll give them an opportunity. They'll say, no, I'm finished. That is disputed. I can't go in. Tomorrow you bring it by way of an additional affidavit also. I'll give an opportunity to Mr. Bora. Mr. Bora will come up and say, we have already said, we are reiterating, this is not there. So this becomes disputed.
One more aspect, my lord. They have provincialized the school also. Another 11 Act, my lord, the school was also provincialized. In that provincialization order, my lord, still not cancelled. They have not withdrawn the order.
But the benefits are not being extended to you.
Benefits are not given to the teachers. They have posted some other persons from other school in the present school. School is still provincial.
Show me the provincialization order.
Provincialization order, law will find at page 34, my lord. Page 34 and petitioner school is at page 42, my lord.
Muslim Sapori LPS,
No, my lord, Saporigaon LPS, my lord.
not 42. Then what?
42, page 42, my lord.
Page 40.
My lord. 116, serial number 116. Saporigaon LP school.
Saporigaon LP School.
Ripun Pegu and Basapi Dole.
So Ripun Pegu and
Basapi Dole.
Basapi Dole were provincialized.
Yes.
And then
You may kindly peruse page 90, annexure 16. Serial number 2 and 5.
just a moment, just a moment. Was any financial assistance given to this court at any point of time?
Yes, madam.
You have received.
Even they are getting the midday meal till today. The school-
Midday meal is continued.
That is continued. School has not been, well, a provincialization order has not been recalled. They have.
Yes, Mr.
some other
Talukdar.
persons in the school.
If the provincialization order is not recalled, why their benefits are not being released?
My lord,
Government has filed an affidavit, I suppose.
my lord. 108 page. And here also we have stated about, my lord, that the petitioner has not died in the year 2009 and 10. my lord.
Okay.
111, my lord. Relevant portion in
110, that letter, 3112.
my lord.
Mr. Sokya,
My lord.
no point in wasting time here. Go before the execution tribunal, establish this. Your order is still holding, we'll protect it. We'll protect it. That provincialization order, we will say it's protected, subject to you establishing that you were in existence from 2000, during the period 2009-10 onwards.
My lord, page 89, Losme Kali peruse. Page 89. The report by the disciplinary division officer, my lord.
These reports are very dicey.
89.
Okay, he is not saying about this dice code from any record. He is saying about the dice code produced by you.
Yes, Malad, then Malad, the director's letter also will find
Hmm.
at page 68, Malad, page 78, Malad.
That numbers.
Yes. Derivation of short code.
This is a communication issued to whom?
Issued to the Malad,
Mission Director SSA,
Malad.
right?
Right.
So page 80 it is there. So in pursuance to this, because they were in doubt as to what is happening. Now, if you come to the document that you just showed me, the affidavit of the respondent number 2. Page 111.
Saying this stand, my lord. This honorable court, my lord,
Where is your reply to this? You have not even filed a reply.
order dated 2/5/2024, my lord. Must kindly peruse the order dated 2/5/2024.
What is it?
Wherein, my lord, a clarification was sought for by this honorable court from the director under what circumstances he, my lord, said that this was the dice code number of the school.
We need not go into that. We have the stand of the SSA. The Director of Elementary Education is only following the stand of the SSA. SSA said 14-15. Right? It's not there beyond that, prior to that. So they say that data was given, so she acted. Now, if this is there, in fact, you will have to establish that. And the only way I foresee, subject to what you say, is before the Education Tribunal. And we will protect your, what do you call that, provincialization order. I'm not rushing into it. You think over it. You think over it. Otherwise, we'll be going round and round, come to the same place again. We'll not be able to fly away. Because I'll have to draw a conclusion basing on this, which I can't.
Considers the order passed in the review petition, wherein, my lord, this honorable court held.
See, again, review petition was followed by an exercise from the SSA,
Yes.
wherein they said that no, a doubt has been created.
Yes.
Now, how can I? Maybe they have something against you. They have done all this thing illegal.
In that case also.
I've seen the order in the review petition.
Dice code was not there for the.
Order review petition order goes beyond 2009. It's from 2006.
Yes.
So
And my school was established, my lord.
84.
India 1984.
84. Yes, Mr. Bora, what do you say?
As per our record, because we keep to that particular record whenever it freezes,
Hmm.
cannot tamper with it.
Hmm.
It freezes. Even in last year also, we can only get a printout. We cannot tamper with.
Now, tell me one thing. Tell me one thing. I understand that the data is from 2014. When was a dice code authorized to this? A dice code is to be authorized. Because I have also passed orders. Somebody comes up saying that, see, my school dice code is not given, this, that. So we pass orders, issue dice code, 7 days. Director, SSA will issue a dice code. Now, what is the material? When was this dice code issued to the school?
Dice, each and every year the dice code, they have to.
It doesn't change. It remains the same.
This remains the same. Every year that they have to give these are the person working, the dias code, that.
Okay,
that's
fine.
inserted.
For the first time, when was the dice code given? Because somebody must assign a number to a particular school. When was that assignment done?
That is 14-15 in this particular case. 14-15.
Not beyond that.
Not beyond that, it cannot be. Once in the year 14-15, from that application has come, SSA has put a dias code in the month of last week
So
of
you mean
November.
to say the dice code number 704 something was given to this school for the first time?
14-15.
14-15.
Cannot go. Then no one can temper it. The month of November is
So
previous,
how
no
come
one
they
can
are
temper.
showing this data of 2009-10?
No, that's why Mala, they need to prove it, all these things.
Yes, Mr. Soike. Think over it. When? Tomorrow? Tomorrow.
Next week.
File forget. Very difficult to keep on remembering these things.
Next week, possibly.
Wednesday. Wednesday. We'll pass orders on Wednesday. Heard the Learning Council for the parties at length. List this matter for further hearing. List this matter again on Wednesday ka date de dena. 18, 19. To enable Mr. Ayat Soikia to place on record materials to indicate that the school had a dias code and was covered by the SSA and had a dias code, and these particulars of the school were captured in the set code against the set code from 2009-10 every year. Also, matter be listed as a part-heard item. And if there is nothing, Mr. You go before the tribunal, prove this. That's the end of the matter.
That all the copies will,
You take this back. I don't
computer
read it.
generated copies.
Huh?
These are not original copies. It was
Need not
supplied-
be. These are secondary copies.
Yes.
You know how to do it. Then, and this is a tribunal. Trappings of a civil court. So exhibit may not be possible, but that being the issue, you will have to, because the issue would be whether you had a dice code from 2009-10. So this would be relevant materials. You will have to bring it on record, then establish. Then they will report. Then if you get it, this much I can assure you, I'll protect your provincialization order till then, but no benefits.
Item 19 and 20.
Arunachalam बताइए.
There is the case, my lord, the petitioner was suspended while in service by order dated 15/9/94. And he has been, the suspension order was set aside by this honorable court. And then he has been reinstated in service. Your lordship will find the item number 19, page 78. Item number 19, page 78.
19 is 1658. Okay.
Page 78, he has been reinstated in service. In compliance of honorable court order dated so and so and person of the golden of 3, Takar Ete, who was placed in suspension by Dajan so and so is hereby reinstated with immediate effect in his original court so and so. That is on 13/8/2020.
Where is your suspension order?
Yes, suspension order. Your lordship will find page 68.
68, 69. It occurred at a assistant chance where the teacher had disobeyed the order number dated 68/94 issued by this office and failed to file reply to SOCOS till date and for which it is here direct to place him under suspension from service. Now then, my lord, he has been, this suspension order actually was not served to the petitioner only when the petitioner has filed the writ petition, then only it was served. Now, he has been reinstated. He reinstated in service. Then after that, your lordship will find an addendum has been issued. That is, your lordship will find page 80, another 70. Page 80. From second part, my lord, second para, it is further added that as per FR 54B 1A and B, the pay and allowances after reinstatement is to be paid to Sri Takar Ate, assistant teacher at Rigby Government LP School at the rate just before placing him under suspension. The decision in connection with suspension period will be taken after receipt of government.
What happened to these disciplinary proceedings?
Yes, my lord. Now, my lord, what happened? So the petitioner has filed this petition praying for his salaries, my lord. The period undergone under suspension, my lord. My lord, because he had the section 54B 1 and so, the period has been regularized or period has been treated as under duty, my lord. So he has filed the petition, my lord. Then this honorable court now.
No, where is that treatment under? So till page 80, that decision what to pay you was not taken.
Not taken. Then
Because
thereafter,
in the
whatever, my lord.
Mr. Sinha, in
Yes.
the meantime, a department proceeding stood initiated against you.
Drawn against me, my lord.
So now what happened to this department?
Yes, my lord. That I am coming, my lord. Now we can go to the second petition, my lord. During pendency of the writ petition, my lord, this honorable court was pleased to pass an order. That is, your lordship will find the first writ petition, your lordship will find page 74.
Date.
Page 74, annexure 26, page 74. Then relevant part, your lordship will find page 78, para 5.
70?
Yeah, page 70, 78. 78, para 5.
What is the date of the order?
13/8, date of the order is 13/3/2023,
Yes.
page 75.
Para?
Para 5, page 78. It is an admitted fact that the petitioner has not been paid his subsistence allowance during the entire period of suspension. The question as to whether the petitioner would be entitled to the reliefs as stated in the writ petition would be decided at a subsequent stage. But the entitlement of the petitioner for the subsistence allowance for the period from so and so cannot be put to question in view of categorical findings in the inquiry report.
Then what happened?
Then, my lord, what happened, my lord? This inquiry report is not the Departmental inquiry report, my lord. It is an internal inquiry, my lord. Now, pending disposal, now the honorable court directed to pay the substance allowance within a period of 45 days and also directed for compliance of the state order. Now, subsequently, they have come with a dismissal order from service. They have dismissed me from service. Your lordship will find the impugn dismissal order. That is at page 80. Now, before that, my lord, before going to the impugn order, now we may go to the focus notice.
Sumiti, show cause notice 13/8.
No, yes, 13/8. There is, my lord, this is the three focus notices are there. three SOCOS notices are there. 31 is 39 issued by the Director of Elementary Education.
Then second one,
Yes. Then second one, same identical nature, my lord. Second one issued by Deputy Inspector of School, that is at page 56. 23,
first writ petition,
21.
first writ petition. First writ petition.
Yes, no, the second writ petition. I have, because I have telling that the impugn order, so I have again wrote all these things, man. The second writ petition, page 56. First SOCOS notice, your lordship will find
53 on.
page 53. The second SOCOS notice is at page 56. Same identical charge
This is by
by
inspector.
Deputy Inspector of Schools. Now, one thing, my lord, your lordship will find the first SOCOS notice 53, my lord, kindly, my lord, 53. First SOCOS notice. Last paragraph, this SOCOS notice is issued on the basis of SOCOS notice served on you from the Deputy Inspector of School dated so and so 16/8/94. Your lordship will find 16/8/94. In the page 53, I mean, the last paragraph.
Then
Now-
the third show cause is 59, page 59.
Yes. No. Second, the third SOCOS is 59. Now,
30,
after that, even second SOCOS notice also, my lord, the last paragraph, your lordship may kindly look into my page 56. Because there is illegalities of procedures are there. If the disciplinary authority decides to appoint
that is
an officer,
normal. Then what happened?
then
Inquiry
no-
held.
No inquiry, I was not communicated anything, my lord. After, my lord, in the first writ petition, they have to comply with the payment of substantial allowance.
So what
If-
is this page 65?
65. That was, my lord, communicated only on, my lord, 10/5/2023.
This is dated 1/4/23.
Yes, my lord, that is a inquiry report.
Hmm.
When this inquiry was made, I was not communicated, my
Okay,
lord.
okay, fine.
No date has been fixed, nothing has been fixed.
Okay,
Who is
fine,
the inquiry officer? I do not know.
Fine.
But
fine.
Yes.
So charges held to be proved.
yes, charges is held to be proved, my lord.
Then what
Yes.
happened?
Then, my lord, this was served, your lordship will find, this was served on 10/5/23.
Hmm.
Now, I have been given 3 days time to file reply against this inquiry report. Inquiry
What happened
report,
to this order?
my lord?
High Court order thereafter? The inquiry report was in all probability put to challenge.
Therefore, the impugn order has been passed. Now, your lordship will find the findings of in the impugn order. I was not allowed to put my defense. When the inquiry has commenced, I did not know anything. Now, the SOCOS notice also does not indicate that any documents are to be.
So impugned order is 12/5.
Yes, 12/5. And 10/5, I have been communicated with the inquiry report, directing me to file a reply against the inquiry report. Now, before completion of the 3 days time, it has been passed. Because on this day, the case was listed, that the first petition was listed, and they have handed over this impugn order before the honorable court. So we have been compelled to challenge this order again. Now, here your lordship will find the findings of the inquiry of, disciplinary authority. The page 80, last paragraph, my lord. Before last paragraph, starting last paragraph, the next paragraph. Further, Director Electronic Assam issued 2 letters to Sri Takar at a Bahait number so and so 24/4/23. That is communication of inquiry report, and 3/5/23.
enclosing the copy of inquiry report submitted by DO Dhamaji, height letter number so and so dated 1/4/23, to submit his written reply against the findings of the inquiry report as to why the penalty prescribed in Assam Services so and so should not be imposed upon him. So now this inquiry report has been served me on 10/5/23, 10/5/23, 3 days time, giving 3 days time. Even in the last letter of this office number so and so 3520, the petitioner Chief Tokorate was informed that reply is not submitted within the specified period, an expertise decision will be taken in the matter. Therefore, said letter dated 24/4/23 and 3/5/23 were received by the Tokorate on so and 10/5/23. Now 12/3 the impugn order has been passed. So when the inquiry was commenced, my lord, when the evidence was, my lord, those documents have been, my lord, produced in the inquiry, and when those, without furnishing me any copy, in violation of that rule 9 clause 2, also clause 4, I was not allowed to put my defense. I was not communicated that the defense will start from so and so, so and so, so and
You are under suspension from 94.
94.
Yes. Where is the unauthorized absence?
Lordship, in this read petition, Lordship, we have filed our affidavit, Lordship.
Forget your affidavit. You tell me, if you have placed him under suspension from 94,
Lordship.
how can that period after 94 be unauthorized absence?
Lordship, kindly jump to paragraph.
And what is this confessional statement in Annexure 1 there too?
Lordship, in this read, we have chronologically stated the facts, Lordship, here.
Get me the records.
Lordship.
Get me the inquiry records. Day after tomorrow, Friday.
Lordship, next week, Lordship.
Friday.
Friday. Lordship.
Let me see.
Yes.
And according to the order, impugned order, on the date when the impugned order was passed,
Lordship.
the proceedings were converted to 1 under 21 because in between he retired. How can you impose the penalty of dismissal on him after retirement? Show me the power.
Oh. On Friday, Lordship, I will obtain.
Mr. Sinha.
Tomorrow is Friday.
Tomorrow is Friday. Then Wednesday.
Wednesday.
Wednesday. Mr. Sinha.
Yes.
Have you seen that order? Penalty order.
Yes, I have seen it.
The proceedings were initiated when you were in service. But in between you retired. So under 21, it got converted to a proceeding under the pension rules. Now, how can the penalty be issued? Its only power is under 22-21 for the governor to withhold pension. That order on that face of it goes. And you have facilitated this man to remain out of service. And now you have to pay full benefits to him. We will require the Chief Secretary to make an inquiry into the matter. The persons who are responsible for this. Because he is being enriched. He'll have to be enriched without. This is not the manner you do. If they don't know, they are not fit to sit there. He is not there from 94, you have placed him under suspension. Why? No proceedings were initiated. Proceedings initiated in 2020. Thereafter 4 years. And by the time he retired. And now he is scot-free. Get me the file.
Yes.
On the next date of listing, Mr. P. Sharma. P.N. Sharma, learned Standing Council Elementary Education Department shall place before this court the record pertaining to the disciplinary proceeding as initiated against the petitioner, leading to the submission of an inquiry report by the inquiry officer on inquiry report is on
1 Yes.
on 1/4/2023,
One.
as well as the impugned order of penalty dated 12/5/2023. Full stop. The Mr. P. N. Sharma shall also address, receive instruction as to how the petitioner, after his superannuation from service during the pendency of the proceedings, could have been imposed with the penalty of penalties prescribed under Rule 7 of the Assam Service Disciplinary Appeal Rules when the proceedings, according to the respondents themselves, was converted to one under the pension rules. Also, the aforesaid instruction along with the records be placed before this court on 19th.
Okay. Obliged.
Affidavit not filed.
Yes.
Not filed.
Not filed.
None has appeared for the, yes. You have got the instructions. Where was this Islamuddin Barbuya working?
I don't know.
Hmm? You don't know. What is this? I don't understand. Order is of Islamuddin Bolaskar,
Well,
right?
Islamuddin, my lord.
Laskar,
Laskar.
appointment order.
My lord.
Person joining is Islamuddin Barbuya,
My lord.
right?
My lord.
Barbuya joined. Was the order changed?
To get instruction.
Why did you waste your time then? What is this written here? Nothing. It only says order was issued in Barbuya, Laskar's name.
Laskar.
Barbuya joined. So and so, and the number has been matched with the existing school. So and so accepted the notice. So anybody can join anyway on the basis of that letter.
And I'll have to.
List this matter again tomorrow, 2 p.m. You get your instructions. Get me your order that the Laskar was changed to Barbia. Otherwise, has notices been issued in this case?
Yes, ma'am.
Barbia is here.
No, my lord, he's not here.
Huh? Notices served.
Yes, my lord. Completed.
We'll see. Tomorrow, get me that instruction.
Most of them.
Item 24.
You ask your director what she is writing. We have not understood. Let her make it more clearer to us in simple man's language.
My lord, in this case, there is an order by this court on 15/2/2024 to obtain instruction on para 3(4) of the improved order.
Order dated?
My lord, improved order dated that is and 28/8/2023, page 99.
What one I thought.
Private respondent has been provisional.
Oh, that matter, category.
Yes, my lord. He never served in the post of library assistant, but he's.
This we'll have to hear. Today may not be possible. We'll have to hear this finally.
My lord, in the meantime, I think my senior colleague has filed an something on 7/6.
7/6 is filed and a reply affidavit.
Reply, but from the cost title, I didn't understand which reply or what.
That you go outside, have a cup of tea,
Principal-
have a cup of tea and then discuss.
The only thing I realized that now is it is the reply to the principal's one. Officially, we have not been received copy from them.
Why tell the court, ask Mr. Sikdar. Mr. Sikdar will give you,
No,
Give you-
yes.
will give you 2
We have-
copies.
No, the
given
principal
copy.
has to give it.
Whoever gives you, these things have to be settled that side, not by this side. On the prayer of the learned counsel for the parties, considering that the matter requires to be finally heard, registry to list this matter again on 17/7/2024 for admissions. An endeavor would be made to dispose of the matter on that day. 17/7, okay?
My lord.
Maybe 24th, my lord.
24.
24th.
24.
Item 25.
May I please, your lordship? Lordship, Mr. A. Galda is on legs, lordship.
No, sir, give me a date. We'll find. That's it. We'll give me a date when it's convenient to you. After vacations, after vacations.
After vacation means July, I'll
7.
not be coming.
Then
July may
August,
not be coming.
August.
August also then difficult. Anyway, cannot be on next Thursday.
Difficult,
Possible.
because now it will maybe declared motion day also. We don't know.
Let it be on 1st of August, 6th of August.
6th of August. On the prayer, as prayed for by the learned counsel for the parties, list this matter again on 6/8/2024. Post up for admissions on our next date Pleadings are complete.
If the pleadings are complete, it may be endeavor shall. be
For
made to
endeavor
dispose
shall
of
be
them,
made to dispose of
to
it.
dispose of them.
Obliged.
It is that school, that scheme you wanted to.
Yes, my lord, earlier judgment was passed, it is.
Got it.
Can I mention one item, my lord?
Hmm.
Item 49, Dismissal for hearing. So it cannot be expected to 49, last item.
What is that matter?
That is, my lord, service matter, my lord, regarding leave.
You want to do it? You want to do it?
It will not be possible, I think. Or it
We will
At
reach.
least 15, 20 minutes will be required, my lord. It's for hearing.
On the prayer of Miss MS N. Soikia, learned counsel for the petitioner,
So that will,
not objected to by Mr. the learned counsel appearing for the respondents. List this matter again on 24th or 26th. When?
24th or 26th. Let it be 24, my lord.
24th.
But it's a hearing matter. Can it be on 25?
25. No
25.
problem.
Obliged.
49. Eh?
No, records were called for, we have received the records.
Lordship,
You know, the learned advocate general will argue for the respondent, my lord. If they want to start, my lord, they can start, my lord.
I don't have that much of patience. We'll hear it together.
Or your lordship will take up after vacation, my lord.
That is for you to decide.
My lord. Otherwise, the issue involved, my lord, 2019, there were two advertisements for grade 3 and grade 4 posts. And after the first phase of the selection, we canceled the
Selection process.
because there were allegations with regard to anomalies in the selection. There were two conflicting repetitions. One saying the selection was bad, and the other for declaring the results. Meanwhile, my lord, there was also a stay order there in in one repetition. Subsequently, that repetition was withdrawn. In the meantime,
This is a cancellation of 2001, right? 25/3/2001, 22. What is that order? 25/3/22. Okay. And a fresh advertisement was issued.
thereafter, these posts were merged in the state levels recruitment board.
Huh.
These repetitions were filed. Initially, there was no stay order. Subsequently, in one repetition 28, I guess, item number 28, there was an order passed by this honorable court not to fill up those posts. 149 posts of grade 3 and 69.
Now they are protected.
The posts are kept back.
But the posts are hanging.
But other
People are
benefited by the interim, so Lordship,
Huh?
let it be after the vacation. The Lordship will just.
Nobody is benefited, madam.
Nobody
When
is
we could
benefited.
not
Public
fill up-
is at large, not benefited.
Yes.
How many posts are involved?
In grade 3, 149. In grade 4, 69, no?
So around
So there are grade 3 and grade 4 posts.
around 200 plus houses
200
can be saved if we finish up these matters. Right? One post is one family.
One post is on them.
On the prayer of the parties, raised it to list this matter again. On when?
Also after vacation,
After vacation.
23/8.
I'm sorry, Lordship.
No further seeking any adjournment, madam.
I am doing the matter today, Mr. If you are ready to do. I have no thing. I can't make that. Tomorrow we don't know human nature. Humans, what will happen? If I put that order, I'll bind myself. Who prevented you from arguing? You should have argued. It's there from 22. I have issued notice in 1 or 2 matters in this case. Next date, come prepared, do it. Huh?
Item 26.
That please allow me. Elephant matter, your lordship, and the first one. On Monday last, your lordship heard this matter.
Yes,
Lordship, the petitioner has been divorced by the employee lordship.
divorced.
Divorce lordship.
Okay, show me the divorce. That talaknama, notary,
Notary.
show me the law that will do.
And everything has
Show
been
me the
done-
law
but
that
everything
is
has been
enough.
done during the period of during the lifetime of the employee lordship.
Huh?
And during the lifetime of the employee lordship, the respondent number 7 was the nominee lordship.
That we are not. Nomination will, that the rule will take over the nomination. Show me the law. Don't show me the paper. That is enough for talak. Fine. I don't know the law. Show me the law. That mere signing of a paper like this,
This is pension order lordship.
pension order, forget it. We are not worried. Pension order, we know how to deal with it. Now you tell me your case. Show me. That talak will do.
There is
In a notary.
No, lordship. There is no provision lordship.
Then you know it better. Then if she is not talaked, she is not divorced, she will have to be. Who is appearing for the department?
But she has not claimed during the lifetime of the employee lordship.
No, my lord.
Oh, that you did not permit her to come go near her husband.
At first,
Maybe.
At first, she filed the 498A before the trial court lordship, and the trial court has been acquitted the deceased husband lordship. Subsequently, the repetitioner filed.
I'm not on that.
125
I'm not
CRPC
on that.
lordship.
Whether there is a termination of the marriage. If there is a termination of the marriage, she's out. If not, she is in. You admittedly are the second marriage, second wife.
Lordship.
50-50. How old are you?
Presently 63.
And you 40 or something.
51.
51.
Presently, she is in the financial crisis of
The petitioner in the present proceedings, I heard Mr. So-and-so, so-and-so, naam le lewa. The petitioner in the present proceedings has claimed that being the first wife of late Abdul Hamid Sheikh, retired. What was he?
Assistant teacher lordship.
Assistant teacher at Katarihara Girls ME Madrasa, she is entitled to the family pension. However, the family pension has been authorized by the respondent authorities to the respondent number 7, who he claims to be the second wife of late Abdul Hamid Sheikh. Full stop. It is to be noted that the husband of the petitioner as well as the respondent number 7 had retired from his services on 27/11/2011, and thereafter, when did he die?
That lordship in the year 2023.
13, thereafter had died on 13/2/2023. Also, it is contended that the husband of the petitioner as well as the respondent number 7 during his lifetime had nominated the respondent number 7 as his nominee for receiving the family pension for the services rendered by him. Also, Accordingly, basing on the said nomination, the respondent authorities on the demise of the husband of the petitioner and the respondent number 7 herein had authorized the family pension in respect of the respondent number 7 herein. Also, the petitioner submits that she being the first wife, she could not have been excluded from the purview of being extended with the benefits of family pension as flowing to the next of kin, to the family of the deceased government employee. Also, per contra, the respondent number 7 contends that the petitioner herein was divorced by her husband, that is the deceased employee, before your marriage or after your marriage? Divorce, talaknama?
After marriage.
After he had contracted marriage with her. Also, however, the learned counsel for the respondent number 7 has fairly submitted that the formalities as required to be followed for the purpose of the divorce to come into force was not followed in the matter, and accordingly it cannot be said that the petitioner was divorced by her husband, that is the deceased government servant. Also, in view of the above and the petitioner herein being the first wife of the deceased government employee, she has a vested right to receive the pension, family pension in her name and the same, and she being the surviving she being the eldest surviving widow under the provisions of section 1, rule 143 of the Assam Services Pension Rules 1969, a vested right is conferred on her to receive the said pension. Full stop. The learned counsel for the respondent number 7 has submitted that in terms of the pension payment order already issued, the family pension is being drawn by the respondent number 7 herein. Full stop. In view of the above position, the present writ petition to whom? Director of Pension or to the Administrative Department?
Chief, one thing I just want to point out over here, Chief, that the Kataria Hara Girls ME School, which was formerly with the elementary education, has been amalgamated with the high school of Kataria High School. So therefore, the
Secondary.
jurisdiction has come with the secondary.
The
They are not a party here.
whom should be a direct? Yes, Mr. Bhattakur, yes, Mr. Bhuya. In such matters, direction to the department or to the direction, Bhuya, Mr. Bhuya also, where? Whom? Bhattakur? To the director pension or director secondary?
Department in full and passing for the PPO.
Pip-
It will transmit it
To the petitioner as well as the respondent number 7 hearing shall, the petitioner hearing shall approach the Director of Secondary Education Assam, staking a claim for being also and for staking a claim for receiving the family pension in respect of the services rendered by her husband, a deceased husband, Abdul Hamid Sheikh, as a teacher of Katkaria High School.
High madrasa.
Today there is no high madrasa. High school.
My lord, ME Madrasa is amalgamated to the High Madrasa.
Now it's high school
It's fine.
with Kataria High School. Also, on a receipt of such representation from the petitioner hearing, the Director of Secondary Education Assam, petitioner hearing along with a certified copy of this order, the Director of Higher Secondary Education Assam shall shall afford an opportunity of hearing to the petitioner as well as the respondent number 7 hearing, and thereafter apportion the family pension between them in the manner as prescribed, and thereafter inform the decision so arrived at to the Director of Pension Assam for disbursal of the family pension involved in the manner as now decided to be so disbursed between the petitioner and the respondent number 7. Also, the Director of Secondary Education Assam shall initiate the said above noted exercise and conclude the same within a period of 3 months from the date of receipt of a certified copy along with a representation from the petitioner herein.
Lordship, the Director of Secondary Education is not party in this case.
Need not be. Need not be. Need not be. If the authority says that I am not a party, so we will not consider. Come back to us. We will do the needful.
This issue is your lordship, settled, your lordship. The petitioners, your lordship, herein are your lordship,
Oh,
assistant teachers, your lordship. And ultimately, your lordship, they were deprived on the ground that they have not yet taken permission from the authorities, your lordship, as per Rule 13, your lordship.
where is the impugned order?
Order, your lordship, the page 30.
34.
34. It discloses nothing, your lordship. When they file affidavit, your lordship, they say in the affidavit, para 5, your lordship, that this is the reason why they have not been considered for interest. And your lordship has already settled this. Your lordship. Para 5 of their affidavit.
Do they say anything about your qualifications? Not that you did not pursue. In addition to that,
No,
do
no,
they say anything?
nothing.
Nothing.
Only that. However, both Rohit Sabugdhara, assistant teacher, and Montu Karpati, assistant
There is
teacher.
a statement somewhere. Although being senior, but you don't have the thing, that's why. Wait. Yes, Mr. Soma.
My lord. Regarding the petitioner number Rohit Sabudara, he is already over age, my lord. Already 50, he has crossed the 57 years.
Okay. And what about Manju Gorpolia? She is eligible.
She is eligible.
But she has not obtained the permission, but it is.
Forget it.
Yes.
Now, are you both senior to
Yes,
Tulsi
sir.
Kaur?
Yes, sir.
From where can I get that?
Your lordship, page 28. Rohit Sabugdara, your lordship.
28. Okay.
Serial number 1. Then serial number 7, next page, Manju Gharpatia.
Yeah, this file had not gone to me yesterday. This file was here over. No, it had gone to me yesterday. This file. No, it might have got tied up with Bangyo. I missed this part. Okay, who has now been promoted?
Serial number 9, Tulsi Kaur.
Tulsi. Okay.
Lord.
I'm sorry, I did not read this briefly. We'll pass on this.
Lord. Deeply.
We are interfering.
Yes.
Dispose of. Just give me
Deeply.
that. Mr.
Okay, here we filed a mistake. Seeking leave to declare the result.
You can
Last
keep this, Mosumi. I think I have it.
directed me to produce the
You will require it in some other case also. Yes, Mr.
on 25/8/2022.
Hmm.
25/8/2022. The petitioner was allowed to appear in the interview. The Lordship we are directed not to declare result without the leave of the Honorable Court. This is the result in the seal cup. Now we have filed application seeking leave to declare the result.
What is there, Mr. Bora?
lordship, things are not what as.
We did not. That you can always argue in the writ petition, but the results, why will it be kept? If you are qualified, you are through. If you are not, you are not.
Your lordship, this whole process is marked by bias and institutional bias.
Mr. Whatever institutional bias,
Yes, Your
I'll
Lordship.
produce judgments to you that you cannot take a plea of institutional bias.
Your lordship,
Then you need not go there. Institutional bias is not a plea to be
the
taken.
conduct
In a
itself is
writ
very
court,
much evident.
institutional
And
bias,
the-
we will not.
And the affidavit also. Your
You forget it. We will
The
not go
affidavit-
with the institutional bias. Bias by certain authorities, fine.
Your lordship, because I cannot pinpoint who that particular person is. but
You
the
make your
conduct
try.
is-
We will permit them to proceed with the selection process. We don't want the post to be kept hanging.
This has been.
The
hanging for
students'
past 8
interest.
years, Your Lordship.
Huh?
This post has been hanging for the past 8 years.
One more day, we will not permit.
Your lordship, what has happened?
I
is-
permitted you last time, second time you were not here. I adjourned the matter.
Your
Today,
lordship,
we are going to open that. If you are there, you are there. We will direct them to appoint you subject to outcome of the writ petition. If you are not there, we will allow them to go ahead with the selection process subject to outcome of this writ petition.
very well, Your Lordship. Then
Mr. Cal, first of all, the present interlocutory application has been preferred by the Assam University authorities, praying for a leave, praying for leave to declare the result with regard to the post of assistant professor. Subject? Agriculture engineering, huh?
Yes, sir.
Agriculture.
Which was so advertised, keeping the same reserve for the OBC category candidates. It is contended by Mr. Cal that the selection process for the said post was concluded on when?
Lordship, she attended the interview on 27/8/2022. 27/8, paragraph 2,
Open.
paragraph 3 of my application.
I'm pretty much sure I'm not selected. I can say. Your Lordship.
Fingers crossed.
By the conduct itself, I can say. Because then if they have wanted me, they could have actually awarded the 30 marks at a time of shortlisting.
We are not foreclosing your rights, Mr. Bora. Maybe you will have to file an application for impleading that person if he is appointed. Was concluded on 27/8/2022. Also. What is your name?
Anamika Yadav.
You are not even there within the wait list number 3 also. Okay, what was the marks not given to you?
That 30 marks for shortlisting. If I may take your lordship to the.
No.
short-
Here, what I find is domain knowledge, knowledge of subject, 50 marks. Mode of presentation, voice, pronunciation marks, 30. Personality marks, 20, total 100. So, other aspects have not been taken for consideration, right? You have been shortlisted, you have been incorporated in the interview.
Interview.
So, you were also marked.
To the.
Parameteria marks. Literally, there is no difference between the marks. 1, 2 marks here, there. And one of the person was selected. 81, whereas you got 62. That 30 thing has not been.
No, that 30 thing, your lordship, that would come at a time of shortlisting. Now, if I may take your lordship.
No, you have been brought in.
Brought in.
Forget that
this
30.
course, on the course
Be
intervention.
that as it may, we deem that you are in. Now, you are in the selection process by a selection committee. There was no reference to that 30 marks.
No, that is not required at all at a time of interview.
Also,
That's a different issue also. That I'll show at the time of. hearing.
27/8/2022. 2022. So the recommendation of the selection committee as constituted in the matter, including the marks scored by the candidates participating therein, including the petitioner, has been produced before this court in a sealed cover. So this court has examined the matter, and accordingly, on finding that the selection process with regard to the post in question is already concluded, and also considering the fact that the said post is also required in the interest, is required to be occupied by a competent person in the interest of the students pursuing their course in the said university, this court hereby grants leave to the university authorities to take forward the selection process and appoint the candidate so selected by the selection committee. Full stop. However, while effecting such appointment, the respondent authorities in the appointment order that would now be issued to the selected candidate shall reflect that the same is subject to the outcome of the proceedings in WPC number 5524/2022. Full stop. It is provided that the order, it is further provided that the orders granting leave to the Assam University authorities to take forward the selection process is without prejudice to the claims made by the petitioner in the present proceedings, which would now be considered on, which would now be so considered in the connected writ petition. Full stop. The petitioner is full stop on the selection being so affected in terms of the leave so granted today in the matter. Mr. Kyle shall communicate the order, shall furnish a copy of the said order along with the address of the selected candidate to Mr. Bora for doing the needful towards impleading the said person in the connected writ petition. Also, raised to list the with the above observations and directions, the present interlocutory application stands disposed of. Return likhable. The raised to list this matter again after 4 weeks on a date to be fixed by it.
Lordship, but fixed date may be given because the petitioner, her age, she is losing the age to apply somewhere else, because what they have done, they have systematically singled me out by not awarding the PhD degree on time. They took 2 years.
Now you have got your PhD degree.
Now
Yes.
they took 2 years. They took 2 valuable years of my life, and they could not actually explain anything in the counter affidavit. Even
Okay.
though
Raised to list this matter raised to list this matter again on 18/7/2024 for further return date. Full stop. The minutes of the selection committee as produced by Mr. Kayal along with the marks scored, marks as awarded to various candidates, to the candidates participating in the selection process is returned, and the same would be so produced by Mr. Kayal if so required by this court during the consideration of the issue in the connected writ petition. Ek hi line apne aaye thi. Tar pisat observation to close.
and the rejoinder also, I have stated new facts. Let them reply to my rejoinder, Your Lordship.
Why should I?
Because
I?
Your Lordship, they will not
Hey,
given a
Ati Gusi,
reply. That is bad for them, in fact. If because they have to compensate me for this particular loss. Your Lordship.
We'll see.
Despite having the honorable court order, till that my salary has not been released, Lordship. And in this case, Lordship, the Bullock Limited officer against whom an affair has been lost, Lordship. He was not arrested, but during that time he was on leave, Lordship. And he obtained the antiseptic benefit from the Honorable High Court and he joined, Lordship. Then pursuant to the and news report, Lordship, that DY 365, an inquiry was conducted against him, Lordship, by the Director of Elementary Education. Lordship will find the page 31, Lordship.
Have you filed your affidavit, Mr. Bora?
No, man.
Why?
Lordship, page 31, for a moment, Lordship, page 31.
You want a disposal today?
Lordship, otherwise there is a direction, only three condition has been given, no pay, no work, or maybe impose stoppage on an annual increment, or it may be transferred, Lordship. This is the findings, Lordship.
You want this court to consider this issue today?
No, Lordship.
Argue.
But my only dear Lordship, I am
Argue.
not getting salary from August to. I am
Argue.
hanging, Lordship.
Argue.
I am hanging, Lordship. My salary may be.
You
less,
argue. What is the allegation?
Allegation is
Keeping
that-
a minor girl, a
Yes,
government servant.
Yes, Lordship.
Is that permissible?
That is, Lordship, that is.
Then?
That's it. Trial is going on, Lordship.
Whither does it mean? Is that permissible? And that too, a person belonging, connected with the education department. If this is your conduct, you're not fit for that
Lordship,
post.
Lordship.
You argue.
Court has, Lordship.
You
yes,
argue,
yes.
argue, argue, argue.
Lordship, I am not on that, Lordship.
You argue.
Lordship is still, Lordship, I am holding.
Forget
the
it.
post. Neither they are allowed to me.
We only want to see whether 31 will stand or not. That's all. Page 31 will stand or not stand. That's all. You argue.
Yes, Lordship, now inquiry is completed, Lordship. Inquiry is
Argue.
completed. Pursuant the GOP, letter number so and so, Lordship, page 31,
Hmm.
and Lordship, finding, Lordship, conclusion last two para, Lordship.
Hmm.
Last
Have they
para,
taken a final decision on this?
Up to Lordship, I am leaving. Lordship.
Have they taken a final decision on this?
No,
Then why?
but here we have sent it to the secretary.
What is the secretary doing?
We have not received any.
Why?
instruction.
You are not representing the secretary.
Yes, I'm
Then?
representing.
Tomorrow morning, give me the information what he has done.
Well, on
Tomorrow,
Monday-
2 o'clock.
Monday, madam, if possible on Monday.
Monday, I'm not coming. Tuesday.
Well,
Mr. Bora shall apprise this court on the next date of listing as to the decision taken by the government in pertaining, in connection with the inquiry report submitted in the matter against the petitioner. Full stop. The said instruction be received from the secretary, the Department of School Education. We'll see.
Next
So
week.
18, 19.
obliged, ma'am.
You remind me of this matter on the morning, 10:30, you remind me.
Yes.
Mr. Bora?
I'll bring. Here also, my lord, I have not
Benefits,
received any instruction. ma'am.
Why has not been released? Salary from date of joining release, but incremental benefit not. Lordship, may kindly peruse page 39. In fact, the district and page 39.
I think
I
here
can
petitioner is receiving salary only, my lord, anything.
What will he do with receiving salary? Her increments from 99, substantial amount. Why? What is the reason?
No, I have not received any instruction. ma'am.
Mr. P.K. Bora, Learned Counsel. On the prayer of Mr. P.K. Bora, Learned Standing Counsel, Elementary Education Department lists this matter again on 25/6/2024, on which date he shall receive,
I'll
complete his instructions and place before this court the reasons as to why the increments of the petitioner stated to be in arrears since 1999 is not being released.
obliged.
My lord, court's order page 17. Here, my lord, I was directed to file an appeal. I have filed an appeal.
No orders passed.
Now, my friend has given an order today, but my lord, my appeal has not been considered in that appeal.
Forget it. What order has been given to you?
They have rejected my case on the ground that I was not recommended by the district scrutiny committee.
Challenge it.
But the order. says-
Mr. Counsel, where is the order?
Order
Order
says-
is,
Page 17.
considering the so and so, 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 shall file an appeal, pass a speaking order. Disip, so and so, while considering this one, shall verify all records as well as give a personal hearing. Now, tell me, with this order, if they have passed that order, where is that willful and deliberate violation? Without willful and deliberate violation, this is not a writ petition. This is
And
a,
after all, in the order, my lord, they have written perused,
you challenge that. Challenge that.
but here, my lord, consider the appeal filed by the petitioner.
Okay, argue. Argue.
Anyway, they have.
You don't understand. What can I do?
concluded.
When there is no willful and deliberate violation, can I come in?
My lord, close me. Anyway,
Give me that copy. Where is that copy? What is the date of the order?
my friend
Date of the order.
D. Kaushik. 20 July 2023.
25.
20 July 27, 2023. Direct.
Mr. M.R. Khandakar, learned counsel for the petitioner, has apprised this court that the respondent authorities, in pursuance to the directions passed by this court-wide order dated 2/11/22 in WPC number 4624/2021, has passed an order dated 27/2023 disposing of the rejecting the appeal as filed by the petitioner in the matter. So, Mr. Khandakar submits that the respondent authority, while disposing of the said appeal, has not considered the matter in the manner in which this court had required it so to consider. In the manner this court had so required. So, in view of the fact that the appeal, which was directed to be considered by this court, has been since considered and disposed of by the said order dated 27/2023, this court finds that there is no willful and deliberate violation of the directions passed by the said order. Accordingly, the contempt petition stands closed. However, liberty is granted to the petitioner to present a challenge to the said order dated 27/2023 by filing an appropriate application.
38, my lord, I'm appearing for the respondent.
38, Mr. B. Kaushik. 39,
39 also, my lord. that's
Same.
provided the copy.
No, my lord, in 39. Kindly peruse
Here
the
we have decided that
court's
he
order,
is
my lord.
eligible, my
Page-
lord.
That is page 25. However, in the event that page 25. The petitioner is found to be eligible for provincialization following the provisions of the said act, so and so the respondent of the provincialize the service of the petitioner from the date of provincialization of the other teachers of the said so and so school, giving him all financial and other benefits. Till that, no provincialization has been.
till date not provincialized.
We have passed the speaking order, my lord.
Where?
My lord, the speaking order is 10/6/2024. I have provided.
My friend, it is also provided, but here no provincialization is made.
They have rejected.
Not rejected.
No, not Mellon. Not.
What
My
are
lord
they
will
done?
find the findings, my lord, the order down below. In view of the above, my lord, it appears that the petitioner fulfills the criteria of provincialization as language feature subject to verification of original certificates. Therefore, the D is hereby directed to verify the original certificates.
Mr. B. Kaushik, learned counsel for the petition, for the respondent, has placed before this court an order dated 10/6/2024 issued by the Secretary to the Government of Assam, Department of School Education, by which the said authority had directed a further scrutiny to be made with regard to the academic qualifications, academic certificates pertaining to the academic qualifications possessed by the petitioner herein from the authority issuing such certificates. Also, the said exercise was directed to be completed within a period of 1 month from the date of issue of the said order. Accordingly, raised to list this matter again after 4 weeks. On the next date of listing, Mr. Kaushik shall apprise this court with regard to the outcome of the exercise now required to be carried out by the Director of Elementary Education in terms of the directions contained in the order dated 10/6/2024.
Director is not a party in the contempt.
We need not. You get it from your secretary.
Secretary.
He has only said, give it, make an inquiry. Then matter will have to go back to him. A copy of the said order dated 10/6/2024 is kept on record and marked as X. He has not finally disposed of the matter. Right?
The consequence.
We'll have to get that. Yes.
Deeply.
40 and 41.
Yes.
Lordships, I am led by Mr. K. N. Chaudhary, senior advocate in this matter. He had to leave Lordships a while ago. Can this be fixed after the vacations?
Ms. S. Chakraborty, learned counsel for the petitioner, submits that on account of certain personal inconvenience, Mr. K.N. Chaudhary, learned senior counsel, who is leading her in the matter, had to leave the court premises. Full stop. Accordingly, she prays that the matter be taken up after the ensuing,
Is 23-7 convenient?
after the ensuing vacations. Full stop. Accordingly, as agreed to by the parties, raised it to list this matter again on 23/7, right? 23/7/2024.
Obliged.
Yes, Mr. Das.
Petitioner also, he has retired from service.
Pension not given.
Yes, pension not given.
Provisional pension?
CPF and.
Provisional pension?
No, nothing. Lordship.
Provisional pension not given.
Only lordship, the GIS amount has, the leave encashment has been given. GIS
I have
and
received here instruction and regard, here my lord, in the instruction, as per instruction, excess royal is there, my lord.
Whatever be, why his provisional pension is not released? Excess royal to what extent?
Excess royal regarding my lord. Excess royal was found due to wrong fixation of two SCPS with effect from 1/1/2012 onwards.
Onwards. When did you retire, Mr. Das?
on 31/1/2023.
31/1/23.
2023.
And what is the law? 5 years. Rafi Mashik,
Traffic masjid they cannot.
how can you? How can you?
And this excess.
And why is the provisional pension not recovered? What is the amount involved?
86,150.
36,001.
86,150.
Now he is retired for around 12, 18 months. Calculate the provisional pension, how much will be drawn to if drawn by him? It will be much more than the amount which you want to withdraw. Withhold. We won the provisional pension order by Wednesday.
Wednesday.
Mr. U. Sharma, learned counsel for the petitioner, submits that the petitioner has not been authorized the provisional pension on account of certain recoveries being required to be made from his pension and pensionary benefits. Full stop. Mr. Sharma has also further submitted that the proposal with regard to broil by the petitioner of his proposal for Mr. Sharma has also submitted that the final pension proposal in respect of the petitioner has also not been submitted to the Director of Pension, Assam. Full stop. In that view of the matter, the Director of Secondary Education, Assam, is directed to authorize to the petitioner his provisional pension from the date of his retirement. Full stop. The recovery, as may be mandated to now be made from the pension and pensionary benefits of the petitioner, shall be so made from, shall be so proceeded in accordance with law, which aspect of the matter would be considered by this court on the next date of listing. However, the same cannot be a ground to deny to the petitioner his provisional, at least his provisional pension. Full stop. The orders authorizing to the petitioner his provisional pension shall be placed before this court by the Director of Secondary Education on 21/6/2024.
This recovery also is not attributable to me. So they cannot make recovery.
Did I say it is attributable to you? Did I say that? Then why unnecessary things? I said we will consider on a given date. That's all.
Lordship may kindly fix it.
21/6.
21.
Oh,
Obliged.
only for your provisional pension. Mr. Das, why are you waiting for? Which matter? Huh? 4/8.
Then OPS, matter, my lord,
Huh?
Lordship knows, my lord, 1996 process initiated, 2001 selected, then thereafter they were not appointed. Ultimately, on the basis of
Selection was completed before 2001.
or in the year 2001,
So they are now under new NPS, they are not given OPS.
they have not given, they ultimately they were appointed in the year 2011, I think, my lord.
Huh.
because of the court case.
Hmm.
So therefore, my lord, it is my lord, settled law, my lord. If the initiation of the process has taken place.
Initiation, the selection, both.
Both. So therefore, only on the ground, that at the time of appointment, there is an undertaking that they will not take this
State government,
OPS. Yes.
State government.
State government.
Have they filed an affidavit?
Yes, they have filed an affidavit. They have said undertaking was
Ha,
taken.
ha, ha.
So that undertaking will not bind the petition.
Brojanath Ganguly. Brojanath Ganguly, unconsignable contract. Okay, we'll hear it then. When?
Tuesday, my lord.
Tuesday, you will have to excuse because much matters fixed. Tuesday and Thursday. If you want the week next,
Date may be fixed, my lord.
25th,
Admission here.
admission hearing, right? Mr. B.D. Das, Learned Senior Counsel, assisted by Mr. J. M. Lotha, Learned Counsel appearing for the petitioner, and also Mr. R. Pujari, Standing Counsel, Finance Department. Also, as agreed to by the parties, list this matter on 25th. 25th would be fine with you?
Yes.
25th, 25, 6, 2024 for admission hearing.
Alright.
There are certain notifications also issued by the
Yes,
government of Assam in this
Recent
connection.
notification is there, if the process has started.
Prior to 2005
2005.
and the selections were completed, then they will be entitled to OPS.
Notification, government of minute says, one of issued by Chief Minister. Government of Assam will.
There is a
consider
notification, I
extending the-
suppose.
How is it?
You have it.
Not notification, is there minute signed by the Chief Minister?
Then I don't know.
Memo number or not?
We'll have it on that day. But I think there is a notification also, Finance Department. How to, just check up.
He's claiming the benefit of all pension
Ah.
laws, OPS. We will defend our case, how he will come within the ambit of NPS.
That's all.
That much.
It says, no, recruitment process started before 2005.
No, that is the norm with the government of India. But maybe I'm wrong.
Division bench
But the
judgment
government
never-
of Assam had also, I think, issued certain guidelines in that line. I'm not sure.
This is on the basis of.
He'll be the best man. He'll know.
In fact, item 48,
Hmm.
which Lordship is taking up right now, is similar to item 44.
Hmm.
In item 44, we have filed a detailed affidavit, thereby taking the stand, how the policy decision came to be adopted, what are the parameters, everything we have taken.
You give a copy to Mr. Das also. 44, along with item number 44. Mr. Das. We'll have it on 25th. Mr. Das is also having a similar matter. Have it on 25th. Right? Only nothing, no immediate cause of to worry in these cases. It's only pension or NPS.
In fact, my case was in the bunch of cases, Lordship, where Lordship, Justice Borua had disposed of number of cases. Justice Borua had himself segregated this case because Lordship, in my case, Lordship, there is a proper advertisement, there is a selection process.
Before 2005. That's why. You have the government of Assam latest notifications on that? No. Just check up if similar notifications like the government and railway was also issued by the government of Assam. Just check up. Mr. Borpujari will do it, but you also make a checkup. And we'll have this both on 25th. 25th of November. 25th. Item number 48. Aru, item number 44. Huh? Duta as per list again on so and so. And Mr. Borpujari, give a copy. We'll not reflect, you give a copy.
Definitely.
Oh. Mr. Das, he'll give you a junior a copy of the affidavit. So that will cover.
May be different because they were appointed on a lump sum basis.
Be that as it may.
Yes.
Recruitment entry is what is required. We'll know the stand.
Yes.
Yeah.
Item 43, my lord.
Huh.
But petitioner, my lord, was duly selected as a precedent of the SMC, my lord. Your lord will find in the writ petition page number 12, my lord. Page number 12 is the resolution, my lord, that was passed in the general meeting on 12/12/2023, my lord. In page number 15, my lord, your lord will find the name of the present petitioner, Razzaq Hussain, as the bottom of page 14, my lord. Page 14, my lord, bottom, my lord. He was selected as the president of the SMC. This resolution was submitted before the DO, my lord, and the DO, my lord, approved the committee. Your lordship will find that into an approval order page number 24, my lord. Whereas petitioner was selected by the general meeting as the president. DO approved the committee with respondent, showing the respondent number 9, my lord, as the president of the committee, my lord. Whereas name of the respondent number 9 is not there in the resolution, my lord. That is my case, my lord. And as per rule 13, my lord, your lordship, rule 13 of the Assam Right of Children to Free and Compulsory Education Rule 2011, my lord. Here, rule 13 specifically say, president, vice president shall be elected from the parent guardian member only, and one of them must be woman. The rule specifically say, my lord, must be selected, shall be selected by the selected or elected by the parents and guardian, my lord. Here in this case, my lord, petitioner was selected by the guardian, but DO approved the name of the respondent number 9 as the president of the committee, whereas, my lord, he was not selected by the guardian, my lord. That is the case.
So you have filed the IA for that interim order.
It's of that order.
Who is now the president of the managing committee?
I am
Respondent
Nine.
nine. Okay, show me. Where is your resolution?
I have filed the objection, my lord.
Where? Here.
11, my lord. 11-6, my lord.
Objection to what? Interim order?
Yes, my lord. I think it is not in report, my lord. I have to.
Give me a copy. What is your case?
Looks.
What is your case?
The resolution which referred by the petitioner, my lord, that was disputed.
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 Okay, both of you will not be there. Departmental authority will hold.
Yes, sir.
You go to the civil court, get your things resolved. We'll set aside your appointment also. We'll not even allow him. Both of you go before the civil court, get it. In the meantime, the departmental authority will hold it.
I have some.
Why?
May I
What
submit?
interest do you have? You have
Yes.
nothing.
May I submit, my lord?
Ah.
My lord, after the resolution.
List this matter again on Tuesday.
Yes.
We'll dispose it of. And
Yes.
this is what we are going to do.
Yes, sir.
We will interfere. Require the, because you dispute his, he will dispute yours.
No doubt.
Finish, disputed question of fact. Why should this court go into? Departmental authority will hold it. And you both go before the civil court and get it settled. Tuesday. On the prayer of the parties, list this matter again on Tuesday for further hearing.
Item 54 of the supplementary list.
Your lordship,
There was an error.
kindly pay-
The applicant has instituted the present.
This, my lord, the date of appointment, the main task of the dispute in the retribution. The lordship preferred the matter of the tribunal. Tribunal would decide, my lord.
No, there is an error in recording the date of birth, the date of joining. I'll have to correct that. From where did I get these dates? Court of Palua, we did Gita. Where are the dates given, Miss Madam?
Kindly page 7, paragraph 2, lordship.
You are referring to paragraph 3, right? Okay. Show me the writ petition. It's okay. Writ petition was not filed by you. It was filed by him. Okay. In the writ petition, where are the dates given, Mr. Counsel?
Yes. Page 51, my lord.
No.
Type to be 340.
Got it. Respondent number 7, Dipti Prakash. Dipti Prakash, so and so, Dipti Prasad Pegu was appointed by the owner 25/11. 25/11, right. So and so was on 11/2. So and so was on 11/4/9. Then 10 was 29/11. What mistake is that?
Lordship, we have annex resolution.
Madam, I am not on that. Paragraph 3 is on a different context altogether. You read paragraph 3, what I have said. The petitioner in the writ petition has projected.
Projecting.
Come to paragraph 3 of the order. The petitioner has projected that she was appointed by the managing committee on 16/11/2000. The petitioner accordingly joined her service. It is the projection of the petitioner that the private respondent 7, 8, 9 were so appointed on 25/11, 11/2, so and so. This is her projection in paragraph 2 of the writ petition. How can it be erroneous? Right? Withdraw this. Can't help it. Ms. S.A. Khalifa. And I have not said that these are the date of appointment. I said this is the projection of the petition. Only that correction you wanted. As Ms. S.A. Khalifa, learned counsel for the petition applicant submits that she be permitted to withdraw the present interlocutory application on interlocutory applications, comma. The same is not objected to by the learned counsel for the respondents. Accordingly, the interlocutory application stands dismissed as not pressed. Mr. Decca, what is this matter of your hearing matter?
Appeal matter under section 58 of the Act.
Will take some time.
It takes some.
We'll have it after vacations.
My lord,
On the
if possible, my lord, date may be fixed commencing in the week commencing 24th, my lord.
will not be possible.
I am the purchaser of the flat, my lord. I am not getting the flat.
My lord, I have thought of not opening anything on merits, my lord. There is a specific order in the interim order that there is no bar for me to transfer the flat to him.
Do
He
it.
refused, my lord.
No.
He refused.
Your personal or your client?
My client, my lord.
Oh, then it's okay. Then you
But there is
forget.
no,
If it was personal, I would have done it now only. Directed now only. Anyway, we'll take a try. New subject, I'll also learn something.
let's give it a try, my lord. Then
Thursday,
Yes.
next 24, last or Thursday, the 27th of Korea. Huh? As agreed to by the parties, list this matter again on 27/6/2024.
I think that will be a motion week, my lord. Anyway.
Some sad solace. He is assisting me a lot in the
Not difficult.
education department. He is making a request, I should keep it.
Not difficult.
my lord.
And I'll get to hear you people on a new topic. Let me also open my
Yes.
vision.
It will be our pleasure, my
There was a pleasure today. Two of your colleagues were here. One was watching, another one was doing. You go to the table, you will get the update.
Oh, yes, I have got the update.
47.
My lord.
Mr. Ghosh, I'm sorry, kept you waiting, but I don't think so. We touch it, it will not be finished after vacation. As agreed to by the learned counsel for the parties, list this matter again after vacations on a date to be fixed by the registry.
Message Lordship. Item number 2.
Ah, yes, I'm there.
My lord, they have filed an additional affidavit today, my lord. I
Hmm.
have to give the reply to.
No need reply.
My
Where
lord,
is that additional affidavit?
It is on
they
the
will
record.
file today.
कोई additional affidavit आएगा Kim? It's not come.
It has come, my lord. I already confirmed that.
It's not on the ये नीचे में देखिए तो है नहीं क्या ये वाला
My lord, it is a page continued form.
नीचे में जो रखा है नहीं ना
40.
page
Page 40.
not come. What is your
Well, I
stand
also
there?
informed my lord from filing section, yesterday they said.
What is
that
your stand there?
My stand is that, my lord.
Show me. Give me a copy.
I'm giving the my copy.
Wow.
Yes.
Any more leftover matters? How many?
My lord, I was working, my petitioners were working in the established.
12 is already on 26. It's already fixed on 20. Huh.
My lord, I've given the status of my petitioner. Now they're depriving my lord, they are terminating me and
The learned counsel for the petitioner submits that an additional affidavit in the matter has been filed on behalf of the petitioners. Also, however, the same is not on record. Registry to tag the same, trace and tag the same with the records of the case and list the matter again on 21/6/2024.
My lord,
Miss,
give some more, 24 or 25, so that I can take instruction from the department also. my lord, that's what I'm-
list this matter again on 18/7/2024. 18/7, enough
Much
time.
obliged, my lord.
much of it.
Not possible today. We'll have it on some other day, after the vacations.
Can it be before vacation 2015 matter?
As agreed to by the learned counsel for the parties, registry to list this matter again after the vacations in the week starting 22/7/2024.
Obliged.
Obliged.
Yes, have you got it? Yes, what happened?
My lord, today he has issued, the concerned authority, my lord.
Miss S. Chutia Learned Council, Standing Council, Elementary Education Department has submitted that the Block Elementary Education Officer is currently pursuing the matter with the public, with the villages of number 3 Borabala as well as number 5 Borabala villages to find out a convenient place to set up the school in question. Full stop. It is stated that the school was required to be shifted to 5 number Borabala village on account of the earlier site of the school being eroded. Full stop. Accordingly, registry to list this matter again on 17/7/2024, on by which date the concrete proposal with regard to the establishment of the school at a permanent site would be placed on record by the District Elementary Education Officer, Nalbari, and the Block Elementary Education Officer, Borkhetri.
So far, inquiry report is concerned, which has been forwarded on 3rd of March 2024.
by the block elementary education officer to the district education officer cannot be ruled out, Lordship. Here it is specific that number 3 has got 59 students without teacher.
They say that they are on the job, they are finding out a space, building to set up that school. So if that place is found out, they will set up the school, they'll come up, we will approve it. We will say, go ahead, finalize it, but let them do that
That should be
exercise.
convenient to the students also, Lordship. Of
The parents.
students, Lordship.
Students, how can these kids give a opinion? They don't have, they are
No,
not
no.
major. They are
Convenient
not
of the
major.
Students should be there, Lordship, because the.
Can a minor give a consent?
No, no, no.
Will it be valid?
I'm not on that.
So let the students give a consent.
Parents will give, but the students' convenience should be.
That will be looked after by these parents. That's why he is talking to the villagers. Let him finish it off. Finish it off.
Number two, fixed on 18th of July.
Huh?
18th of July, item number 2. Maybe fixed, I may not say 18th of July, I have seen. And it's fixed on either 23 or 26th of July.
20?
23, 23rd or 26th.
23rd, 23. You inform Ms. Gynok.
Yes, I must have less.
23, 7. Age hai agor kisto. 20. Eh, no, no.
Item 2.
17.
Yes, today not possible.
That may be fixed.
As agreed to by the parties, list this matter again after vacation period on a date to be fixed by the registrar after vacation.